relevant clause in the vacancy circular, my lord, has straight away has page 135.
Oh, that clause 6, small Roman
Yes.
6.
I've examined that.
Yes. 130?
134, page 134. It is at page 133.
The entire provision is quoted.
No, but I'm referring to the circular itself. That is at 133.
Oh, so this is specified in the vacancy notice.
Vacancy notice. My lord sees the way we understand it, my lord. The first point is maximum 30 years as on closing date for receipt of application form through online mode.
Where are you reading this at 133?
134, my lord. So
age limit. You are reading age limit.
Yes, my lord.
Yes.
Now, my lord will see Roman 1 is maximum 30 years as on closing date for receipt of application form through online mode. Now, clause 5 provides for age relaxation. Age relaxation admissible in respect of reserved categories of candidates permissible over and above age limits of RRs as per Government of India, Andaman and Nicobar Administration's instructions are as under. Now, kindly have serial number 8. Age relaxation to DRMs and contract employees including SSCT. SSCT is the concerned applicant is SSCT of ANN
Which stands for?
It stands for Sarva Shiksha Contract Teacher of ANN Administration. Now kindly see, my lord, the upper age limit which is prescribed in accordance with instructions orders issued by Andaman and Nicobar Administration with a circular dated 19/9/2011 up to 40 years of age as per DOPT Government of India. So two things. First, there is an age relaxation for the years spent in service as a contract teacher. This will be further apparent from the 19 September 2011 circular, which I'll just show. And secondly, there is a upper age limit prescribed of 40 years. Now, clause 6 says.
So therefore 40 is the limit.
40 is the limit.
Whatever may be the service, he will not get more than 40.
Yes.
So let us take it at 40.
Absolutely. Now kindly see, the CAT has relied upon clause 6. Clause 6 says, in addition to above, one time 2 years age relaxation granted by the Honorable Lieutenant Governor over and above upper age limit as prescribed in the recruitment rule shall be extended to the candidates for current recruitment with the administration's order dated 20th October 2022. Now the question that has arisen is, this 2 years additional relaxation, according to the administration, is still subject to the upper age limit of 40 years, which is prescribed by DOPT. So there is a power of relaxation which the Lieutenant Governor has, but so if he was, so for it's 30 plus 2 basically. Now the question is whether reservation can be applied cumulatively or not. If there are several categories of reservation, or age relaxation is somewhat similar to reservation itself. It's a special benefit which is being conferred. Now, whether somebody can claim that I am entitled to this age relaxation under clause 6, clause 5, and at the same time, I am very well, you may still be entitled to 2 additional years, but it will still be subject to the upper age limit of 40 years. So this is the question, my lord.
So where is the administrative order dated 2010-22?
2010-2022, my lord, I've in fact, it is not, that is the first September one is annexed, but I'll just hand over, my lord. I can file it subsequently. Kindly have. Hey, Manoj. Sorry, they have printed it on, but this is 20th October is on one side. Now, kindly see, these are the two notifications. 20th
Just allow us to read a minute.
Yes, my lord, sir.
Last sentence of paragraph one, of paragraph two.
Yes, well, it says age relaxation available to various categories shall also be applicable over and above the relaxation now given.
Now.
But my lord, the question is, if my lord has page 145 of the petition,
145.
145. This is the office memorandum issued by the Government of India, Ministry of Personnel, Public Grievance and Pensions. Now kindly see what this says. The undersigned is directed to invite attention to instructions contained in Departmental OM dated 20th July 1976 and Office Memorandum dated 9th April 1981 regarding relaxation of age limits of departmental candidates for appointment to Group C and Group D posts. The staff side of National Council suggested that age limit for departmental candidates to Group C and D should be liberalized. They contended that in case of Group D employees, there is no scope for promotion in normal course and there is justification to increase age limit at least for government servant to compete for higher grades of direct recruitment. The matter has been carefully examined. It has been decided that departmental candidates may be allowed to compete along with candidates from the open market up to age of 40 years for Group C post in case of general candidates and 45 years in case of scheduled caste and scheduled tribes. So, my lord, so far as the UT administration is concerned, my lord, the central government is paramount, my lord, because the lieutenant governor cannot do anything which is, he's only acting as administrator, my lord.
This operates in the same field. It says departmental candidates.
Yes, so this Group C, 40 years for Group C posts. So, my lord, how it operates,
No,
I'll
it
explain.
says
Yes,
this-
I appreciate that. Kindly have page.
The whole purpose of this of OM appears to be that, in view of the fact that certain posts do not have any career enhancement.
My lord.
Therefore, they are being given this relaxation
Yes,
so that from Group D, they may have the opportunity of climbing the ladder to Group C. That doesn't appear to
no,
be the
Group C,
situation here.
Group D, it says 45, Group C 40 years. Now, this has been extended to contract employees by virtue of page 144, 19 September 2011.
19 September 11.
Yes, Manu. It says, just the page before, reference is invited to administration circular dated 6 June 2001. Guidelines issued regarding age relaxation to certain categories of employees. The matter regarding extension of similar age relaxation to daily rated Mazdoors and contract employees, including those appointed as Sarva Shiksha contract teachers who have been working as such for prolonged periods has been engaging the attention of the administration for quite some time past. It has been brought to the notice of the administration that although the above categories were well within their age limit at the time of the initial appointment, however, over a period of time, they get overaged when the regular vacancies become available, thus depriving them of their chance to apply for regular appointments, compete with others. It has therefore been decided that all such candidates would be eligible to be considered for age relaxation subject to the actual period spent as SSCT ad hoc contract for working in the department to which they are applying. However, in case of DRM ad hoc contractual workers, the total period spent in each of the departments of the administration shall be counted irrespective of the department where they are applying for regular appointment, provided the post is general and it doesn't require any specific technical qualification. It goes without saying, for all cases of age relaxation are subject to primary conditions. At the time of the initial engagement, these employees were not overage. So by virtue of this circular, the contractual workers are also being given the benefit of age relaxation.
And this is issued by.
This is, my lord, issued by the administration.
So therefore, the earlier submission that it cannot be, the local administration cannot issue any circular or memorandum. You're relying on this, that destroys your very first submission.
No, my lord, my submission is that by virtue of this circular, age relaxation is being given.
That is a
There is
different
no
submission, but you said that the
No, but it is
administration
subject.
cannot.
No, what my submission, my lord, is that it is subject to the upper ceiling which is placed by the central
That we
government.
had submitted to begin
So,
with.
my lord, that is the only because if my lord comes back to page.
But then that's why we have asked you to make submission with reference to that paragraph which we just
Yes.
pointed out.
My lord.
Clearly says in the last,
134.
the 2010-22. This is under a special circumstance issued by the government. Since there was no appointments made, this is only to further the objective of the earlier relaxation, otherwise it becomes meaningless. This is the only.
No, my lord, my submission, my alternative submission.
The last sentence makes it quite clear. The age relaxation are various, available to various categories shall also be applicable over and above the relaxation now given. So this is the relaxation now given, which you have just placed, and then it says over and above.
No, but my
No
lord,
ambiguity appears to be
no,
there.
my submission is that this cannot trump over the ceiling which is placed by the central government.
No, then if you say that, then how are you following this 19/9/2011?
19/9/2011 is only extending the benefit to the
Cannot do a
contractual
hot and
workers.
cold at the same time. That you cannot do.
We are relying upon 19/9 only to say that the relaxation has been extended to
Only or
contractual
not
workers.
only, either you can rely or you cannot rely.
But
There
the-
cannot be a limited reliance on a document which you say will not apply.
My lord, our submission is that
So
19/9,
that,
the
you cannot
benefit,
say hot and
the benefit which was being given to
that we have understood.
government servants is being extended. So, but what benefit was given is again subject to the ceiling. So the ceiling, so my lord, if my humble submission is, my lord, that this at page 134, clause 6,
Yes.
the relaxation under clause 6 can be added, but provided it doesn't exceed. And secondly, my lord,
When it becomes redundant, then
No.
clause 6 has no meaning.
it has, my lord, for
Please read
example,
clause 6. Please read
in
clause
addition
6.
to the above.
In addition, it says in addition, it opens with the expression in addition.
Yes, my lord.
Therefore, what
Certainly.
you are saying cannot be
So to just
based on
to
a
make
plain reading of the
make an
document.
effort,
That submission
to
will
make
not
an effort to explain how it can operate together. So for instance, if this person was not was 30 years, then they would get.
It's not a question of this individual case. It is whether that 2 years in addition is to be given or not.
No, 2 years in
Whether this
addition
clause
will be
6
given.
Whether clause 6 is redundant
It
in the employment notice or it has some meaning.
No, it has, my lord. What I am submitting is, my lord, clause 6 will be added as long as the upper age limit is not breached.
That you have said. On that you have said enough time.
My lord.
We have understood, yes.
And
What has the tribunal held?
there's some judgments also I wanted to cite. My lord, the first is a recent Supreme Court judgment, my lord.
Can we see the tribunal?
Yes, certainly.
We'll see your.
The 125 it begins.
Also been quoted in.
My lord. My lord, the first judgment that I want to rely upon is of the Supreme Court, where, my lord, the court has laid down that as a matter of principle, there is no right to relaxation, and as long as there is no discrimination, this is also a case where there was a power to relax under an additional power to discretionary power to relax, which was not exercised. And kindly have, my lord, just two paragraphs I'll read. First, my lord, may have para 12. Rule 3, para 12 at page 3. Rule 3 of the age relaxation rules of 1992, which is extracted above, begins with a non-obstante provision, which operates notwithstanding anything to the contrary contained in any rule, regulating the maximum age of recruitment to a service or post in connection. Para 12, I am reading. Third, mine. My reliance on this judgment is to the effect that this is the case of the applicant is not as if somebody else has been given the benefit beyond 40 years. So there is no case of discrimination.
That you are relying upon is completely.
No, my lord, I appreciate there is a difference in the facts.
It says that when it is not being granted to anyone, she cannot seek it as a
So
exception.
even in
That is
this
not
case,
the
it is
case
being
here.
granted.
Here your employment notice itself contemplates.
No,
There is no question of.
my lord, my
seeking
submission is that the
special-
employment notice has been read in the same manner for everyone. It is not as if somebody has been given 40 plus 2. My lord, the next judgment, my lord, is specifically in the context of this cumulative application of this is of the Bombay High Court, my lord, but I am relying a full bench of the Bombay High Court. I'm relying on it only, my lord, because I felt that it would be useful, my lords, in assisting the court. My lord, here, my lord, the court has looked at Article 335 of the Constitution to look at the requirement of efficiency of services read with the power of relaxation. Now, here the court has actually looked at it to say
Which circular was in operation in this case? Let us see. Which circular was being considered? Which age relaxation circular was being considered?
yes, kindly see first paragraph 4. This is actually a full bench on a reference, my lord. They have decided this issue.
Therefore, we are asking you which age relaxation circular was considered, because here it is only a question of reading the age relaxation circular. It's not a question of anybody claiming an exclusive benefit not given to others or anything. Whether the circular employment notice read with the 1909 and 2010 arrives at this conclusion or not. That is only.
No, I appreciate my only.
So therefore, is there anything here that
No,
interpretation?
my lord, the circular is not evident, my lord, but point is, my lord, what I'm submitting is, I just want to place 2 paragraphs to say, my lord, that ordinarily the court will read the reservation or age relaxation non-cumulatively. So unless the circular is so clear.
Correct. So therefore, we are saying whether the 3 circulars harmoniously read will arrive at a conclusion so as to sustain the cat's judgment or not. That's all. Nothing else.
So my lord, my humble submission is that this circular is not so clear as to say that age limit, like 40 years age limit may be ignored. So my submission is.
Ignored. Where's the question of ignoring?
No, in the sense, not ignoring.
It's not
in
a
the
question of
not
ignoring.
applying, or
It's
rather
not a question
relaxing.
of not applying also. It is a question of that applying and over and above that.
Yes,
A
my lord.
further 2 years
Yes, my
applying.
lord. So-
Both applying.
So the way I am reading the circular is to say that 2 years benefit is there, but it is subject to a upper age limit of 40 years, my lord. That is my only submission.
So in no case the candidate will get more than 40.
More than 40.
This is
Yes.
what you are saying.
Yes, that is my only submission. Your lordships may consider
Yes.
giving an opportunity to serve, my lord, and come.
We are not satisfied with the question of issuing limit. Yes. You are for the administration.
Yes, my lord.
The Learned Council representing the administration has assailed the order of the Central Administrative Tribunal, Calcutta bench, within brackets, circuit sitting at Fort Blair. The order is dated 4/9/2024. Stop. By the said order, the tribunal has directed as follows. Reproduce para 13 from page 130. In order to appreciate the issue, we are giving a brief narration of the events leading to the filing of the present writ petition. The respondent came out with. Yes, while the dictation is in progress. Writing should indicate dictation in progress.
Come to WPA P1 of 2025.
तो बोलने दो एफिडेविट में बोलना पड़ेगा
Sir, I am the petitioner in item number 2.
Any update question? Photo number is-
Sir, I am for the respondent number 2. Police
I'm
authority.
appearing for the respondent number 1, man.
Sir, in this matter, sir, the STS bus, State Transport Service bus, which is running without a valid insurance and registration certificate and fitness certificate. So, for that reason, there is an accident occurred in rest camp Mayabandar, for which the 4 people died, and the youngest one is 14-year-old, and no one is taking responsibility for that. So, what my prayer is that an investigation should be carried out, and all the buses which are running. Yes.
Mr. Paul,
Yes.
your voice is slightly muffled and not coming very clear.
Sir, I think there's no issue from my side because the internet is good from my side because.
कम करने थोड़ा कम करने. Yes, can you repeat what you are submitting?
Sir, actually, I am an IIT Bombay postgraduate, and I am a social worker. I fought the 2024 Lok Sabha MP election from Andaman and Nicobar Island. What I found is that on 15th, from the media report, that on 15th November 2024, a fatal bus accident occurred at Mayabandar near rest camp, and because of which that 4 people died, and the youngest one is 14-year-old. Sir, in this, what I found is the bus is running without any valid fitness certificate and registration certificate, and there is a shortage of staff to conduct fitness of the buses. And majority of the STS buses at Andaman and Nicobar Island is running without a valid fitness certificate. And this is the main cause. This is not only hamper the safety of those who are sitting on the buses, but also on the passengers. There's a grave risk for the travelers, for those who uses the roads. So what I want is that an interim order may be passed that restricting the usage, that the STS department should not to run any buses without any fitness certificate, and an investigation should be carried out, and FIR must be and direction may be issued to the DGP to register an FIR against the director of the and secretary of the transport, so that they can be punished according to law, and the compensation, adequate compensation should be provided to all those who died in that fatal accident.
What is the decision that you have annexed?
Sir, I have the media reports. I have filed RTI also, seeking the details of the buses.
This is relating to him being provided legal aid because he has had a run-in with the.
No, sir, this is about other PIL also I have filed. This is nothing to do because this is I have annexed the media reports, local media.
Legal aid. That is why he annexed that order.
Mr. Paul, you want us to understand something, then don't speak side by side.
Okay.
We asked you to say what you wanted. Now, when he's submitting, don't speak side by side. It is impossible for us to understand anything.
Yes, sir.
This, my lord, is unrelated to the facts of this case. This is in connection with his own disputes with the local bar, my lord, where, my lord, the Supreme Court has appointed a person from the Tis Hazari District Court, Delhi, to provide him legal aid.
No, what is this? This is not in relation to
Not
the
in
present-
relation to the.
This is not in relation to the present issue that you are raising.
No, sir, it is related to the present issue.
Why this order was passed in which case?
Sir, I have attached I have given the documents that I am fighting for the causes of the common people, and the how advocates as well as the local administration is harassing me. That is the reason that entire story I have put it in the petition. Then nothing. This is the related one. Then the annexure, if you say P8, annexure P8 to P8, I have annexed the local media reports, which says that there is a accident, and the reason for the accident is that use of unfit buses without any valid registration certificate and fitness certificate, and because of which the accident occurred. So this is a PIL. So I have attached that what are the facts of the cases.
But where is the order of 10-1-24? It was recorded in para 1 of this Supreme Court order.
मैं 10-1 का तो order नहीं लगा है।
Yes, Mr. Paul, we are asking
High
you.
Court का order ये
Yes, sir.
In paragraph 1, there is the reference to an order dated 10-1-24.
10-1-24.
Paragraph 1. Have you got it? P7, page 29.
So page 29, yes.
In para 1, there is reference to an order of 10-1-24. Where is this order, 10-1-24?
10-1, this could be English with order 10-1-24. So I think I have not attached the 10-1-24. This is an application. This is dismissed by the High Court. That this is 2-line order, sir.
You said that it is relevant to the present case. Therefore, we want to see where is this 10-1-24.
Sir, I think the 10-1-24 order is not attached to this PIL.
Sure, give it to us.
Okay. So this is the, actually I have submitted a writ petition where the Calcutta High Court dismissed that the advocate, it is also described in this petition. So I think,
First time when you said this, you need not repeat that submission.
yes, I understand, sir.
So that you submitted that this order is relevant to the present case. Therefore, we want to see what was the 10-1-24.
Okay, sir, I have not attached, I think by mistake I have not paid to attach.
The supplementary will consider it.
Okay.
You file
Okay,
it
sir.
tomorrow?
No, sir, actually I am at Delhi now. It need time, sir. It 9 time because by within 10, yes, sir.
How much time? Can you please repeat?
Sir, 10 days time I need, 10 days time. So after 15, by 15 I'll submit.
For the respondents raise an objection to the maintainability of the PIL, Learned Counsel for the petitioner has drawn attention of the court towards Annexure P7, page 29, being an order passed by the Apex Court on 1/3/2024, full stop. It is submitted that the said order is relevant to the petitioner pursuing the present PIL. In order to appreciate such submission, we requested the petitioner in person to show us the order dated 10-1-24 referred to in paragraph 1 of the Honorable Apex Court order, which he submits that the same has not been annexed and that he will be filing a supplementary affidavit placing that on record, for which he requires 10 days. So let him file such supplementary affidavit within 10 days after due service upon the Learned Counsel representing the respondents. Would stop reserving the right of the respondents to pursue their preliminary objection. Would stop, we adjourn the matter to be taken up in the next available circuit.
Sir, this is an urgent matter, and interim order may be passed directing them that not to allow the buses without a valid fitness certificate. This is PIL.
Next case.
Item 3, WP 44.
In this case, Your Honor, advocate on record is in unwell, is went to mainland. So come back on Friday. So let the matter may be fixed on Friday, my lord.
Who is, you are for the other side.
No, my lord, I am appearing for the other.
Friday is all right.
Let it be, my lord, on Monday, my lord.
As jointly prayed, list on Monday.
Friday, now.
Item four, CRA four of 2024 is plan one of 2024.
So I am for the respondent state.
Lordship, I am for the appellant lordship. It is a statutory appeal lordship, against conviction lordship. 10 years conviction lordship, 6 years already the appellant is in custody lordship. The victim girl happens to be his wife lordship. It is a POCSO
Fine, SAT 16 of 2024 with CAN 1 of 2023.
What in this matter, I am for the appellant in the matter. As per the direction of this honorable court on the last occasion, I have filed a section 5 application and I was directed to serve the section 5 application to all the respondent.
I am appearing on behalf of respondent number 1 to 6.
There are 7 respondents.
1 to 6.
There are 7
So
respondents.
that is all the
No,
respondents.
no, one more respondent is there, Lordship. I have already served. I have the affidavit of service.
So respondent number 7 is the
7 is a
private.
pradhan. No, he's also the government authority. He's a pradhan of that area, Lordship.
Of the local body.
Local body. So I need some time to get the track report. Since it is an inter-island matter, Lordship, I need some time.
The Senate Council appearing for the appellant submits that the tracking report, the track report in respect of service on respondent number 7 is still not available. So he requires some further time for placing affidavit of service in reference to the up-to-date track report. So next circuit,
Lordship.
as paid next circuit.
I'm grateful, Lordship.
Item 6, SAT 17 of 2024.
I can take either of this side because it's an appeal, second appeal coming for the first time for admission because there is no adverse side to me. Unless this court admit and substantial question is framed.
There is no delay.
No, no, it's within time. It's within time.
So apparently there are no dispute on the facts.
No, no, it's
What
second,
is the-
second appeal, my lord.
No, but what is the statutory effect? That has to be seen.
What has happened?
Regulation 38
My lord,
can be read,
my suit,
can be ignored in view of 161.
my lord, my suit before the trial court was all about seeking a declaration of possessory right. The trial court went on a premises as if it's a suit seeking declaration based on adverse possession. The Gurdwara Sahib judgments was relied by the trial court, whereas my case was not that. I simply said, I'm a squatter, I'm an encroacher of a government revenue land, my lord, in this island. Encroachers have certain rights which are.
Let us see, that's what you
I
want to.
will draw laws to that. Just
Yes.
give I'll just give the facts in nutshell, now, so then I'll draw laws to the law.
That is why we have gone through. We have seen,
My
you
lord.
say you have been in occupation, you are a squatter for 30 years.
My lord.
And therefore, there should be a declaration in your favor and mandatory in that.
Possessory right I claim. You evict me with due process of
You
law.
say that it is claimed under a particular provision. Let us see.
Let me do not. Yes.
And where is the 66 regulation?
The court also, there's a two books. I can just say. But it's a special regulation which is operating the field in this island.
Yes. Can we take it up on Monday? Allow me.
My lord, my lord,
Speaking for myself, I would like to go through.
my lord, my lord, my lord, my lord, my lord.
List on, give the date of Monday. You send this file over the weekend with this on Friday.
Item number 7, SCT 18 of 2024.
Lordship, in this matter, I am for the appellant. Here also the same situation, there is a delay. There was a direction to file the section 5 application. I have already posted all the to all the respondent and filing the affidavit in service, Lordship. It will also take some time to get the track report since it is an interim. Last case serial number was 5, Lordship.
State of respondent number 7, state respondents.
I'm grateful.
Number 8, MAT 16 of 2024.
My lord, I am looking for this. My lord, service has been.
I am for the private respondent, your sole private respondent. I am filing in Wakalat.
I pay for respondent number 1, 2, and 3. The official respondent may not.
Yes. What is the order under appeal? Let us see whether there is any. You are for the respond number 4 in the writ proceedings. You were respond number 4 in the writ proceedings.
No, I am the petitioner.
Then why have you come? There is orders passed in your favor.
My case was that earlier the writ court, in three expedition, different the private respondent to construct the written record. Because this private respondent excavated the earth from the common boundary. My house is in the upper side. So the landsliding situation, my house is in endangered condition. So initially I lodged the complaint to the subdivisional magistrate and issue 133 of CRPC for condition order. And then
How 133 will apply here? Where is the common passage which is being obstructed that you will rely on 133 CRPC? You cannot file a provisional. Just show us 133. How 133 will apply? 133 applies to remove an obstruction, not to create a boundary wall. Please read 133. You are relying on 133. Let's see.
I don't do order.
Sir, please read 133. You can't just throw a section at us like this. Read it.
Thing has been happened, I am submitting.
You say it is in compliance of 133. Let us see how 133 will apply. That is a different thing. You are mentioning a statutory provision as it has a statutory foundation. So let us see what 133 says. It only says removal of obstruction of a passage being used. If we remember correctly, let us see. It does not say of erecting any wall or construction from tanks or passage. That is perhaps the purport of 132. Then unlawful obstruction or nuisance should be removed from any public place or from any way, river or channel, which is or may be lawfully used by the public. Where is the question of erecting a wall pursuant to an order passed under 133? There is no jurisdiction to give a direction like this. There is no such jurisdiction. Whatever the court has allowed you, you take your own measures if you want to save your land. The court has further said that even if respond number 4 comes in your way, then yes.
There are three directions. First, WP number 555 of 2009, the Honorable Writ Court directed the private respondent to construct the retaining wall. What was the submission made by the private respondent that yes, I will do it. But after demarcation of the demarcation was held. Thereafter, he has not constructed the retaining.
Then go for contempt.
Now, what happened there?
A subsequent writ petition cannot be filed for that.
Petition with the Honorable Writ Court directed to comply the order passed in the writ petition number 555 of 2009.
Sir, that is why no, we have understood. That is why we are saying you can keep on filing writ petitions. Then for 10 times the court should issue a direction for complying with the order, or ultimately you have to take a step for compliance of the order.
Some subsequent development.
We have seen that.
Subsequent development is that direction was there. Now, what happened? In the meantime, the administration found that the license which was obtained by the private, that was obtained by committing fraud. License has been cancelled, but still he is enjoying for last 9 years. He is enjoying the site land.
That will not cast an obligation on him to construct a wall for you. That will not
taken. But stand taken by the private respondent that no, as the license has been, I am unable to construct the retaining wall, unable to comply.
The court has given you the liberty to take steps for your protection. Not directed you, gave you liberty.
Liberty.
Yes. If you want to take steps to save your property, the court has said you do it. The court has further said that if respond number 4 comes in this way, they will also take care of that. What more do you want? Why they should be directed to construct your boundary wall?
Of the wrong done by the private listener, I may not be victimized.
Then for that you will have to go before an ordinary court in a civil proceeding, if you want to raise grievances between you and the respondent number 4, then the writ proceedings is not the jurisdiction, sir.
Clear that either private respondent or to administration
Yes.
to take care of the retaining, construction of retaining
We
wall.
think sufficient
government will-
direction has been issued. We think sufficient direction has been issued. In fact, the direction has been issued, so we are not saying anything, but it is a private dispute between you and respondent number 4. It is more than obvious. It is more than obvious. And that the court has held.
Let me file the paperwork.
For what, sir? We are looking at the order, we are hearing you. What paperwork you will do?
I specifically where before the honorable.
All right. That will consider whether your prayer should have been acceded to or not, whether your prayer vis-a-vis a private respondent and a direction was to be issued to a private respondent seeking construction of a boundary wall to safeguard your property. That is all right, then we'll consider that.
Filed the three petition.
Yes,
That direction has already been filed in three petition.
that you have submitted 3 times. That you have submitted 3 times. That we have understood. Don't repeat. Yes.
Now, what stand taken that as the license has already been.
That also you have submitted. That we have understood. Everything you have submitted. Still we say, is the writ court to issue a direction against a private respondent for constructing a wall to safeguard your property?
And because this situation arose. in the wrong committed
We
by
think
the-
sufficient liberty has been granted to you. If you don't want to take steps for your property, then you don't. Nobody is stopping you.
I don't have any money to construct the retaining wall.
That also we'll consider. That also we'll consider.
Pension. And this situation arose on the wrong committed by the private respondent.
Earlier order was issued in which writ petition?
For present order, entire thing has been taken. The order which has been issued by the other expedition is reported in this in order.
First, WP number 555 of 2009.
Starts from page 2, 3.
My lord, para 3 of the judgment, my learned friend is
Yes. Petition number, WP number 555 of 2009.
What else? So earlier it was passed. What else? Your submission?
In this writ petition, this writ petition was filed by the private respondent, challenging the order passed by the learned subdivision on it. And in this writ petition, this honorable court directed the private respondent to construct the retaining wall to comply the order. He said, yes, I will comply after demarcation of the land. Demarcation was held, but no construction has been made. Thereafter, it's WP number 90 of 2010. And then WP number 1128 of 2011. There are 3 writ petitions.
Earlier 2010 and
Then WP number 1128 of 2011.
all these orders, the order was passed in your favor.
Yes.
Any other submission?
No. In the petition, 3 petition, when the direction was passed.
So
the last
3 orders. Part of the paper book. No, they are not part of the petition filed by you.
More appeal.
So 5225 was filed by respondent number 4.
Yes.
Yes,
And then next one is WP number 90. It was filed by me because the demarcation was there without giving opportunity of hearing. So I have challenged it to this honorable court. Again, in the same, the honorable writ court directed to comply the order passed in WP number 3.5 of 2000.
and you chose not to file any contempt. Then where is the third order?
But what I 1128, next one. The content high, it was dropped because of the reason I failed to produce the demarcation at that point of time.
Contempt has also been dropped.
Yes.
What was the number of that?
Perhaps I enclose the order with that.
The reputation. The one we are seeing.
Very short.
Page number 57.
Hello. Very good. Yeah, after this order, the license of the land has been cancelled. The traffic challenge it before this, the honorable head class. And in the report, the status quo order. That is the reason I could not able to file any contempt subsequently after getting the certified copy of the demarcation.
Unless until the demarcation case is decided, you cannot file a contempt petition.
That was decided.
When?
Action was done,
When?
subsequently.
Demarcation has been done. Then after that, why did you not file a contempt application?
Because there was a status order.
That doesn't come in your way. The court's direction is that if a demarcation is done, then only he will construct.
It is subsequent.
We don't know where is that order. The writ petition is not maintainable. I don't know. We don't know how this direction was passed. But we think that you have been given more than what you were entitled, and you are not satisfied. We are not inclined to interfere with this order. Yes, take down. Yes, please take down. You are all representing the respondent.
Yes, my lord.
Give your appearance.
My lord.
The writ petition was filed by the petitioner, praying for issuance of a direction upon the respondents, state respondents, to construct a retaining wall on a government revenue land bearing survey number so and so, para 3 of the writ court order, at school line, village near Pahargaon, under Port Blair Tehsil, which is admittedly now in occupation of the respondent number 4. The Senate Counsel for the petitioner submits that the respondent number 4 was in possession of the lands below the petitioner's held lands and was excavating the lands. So the same endangered the petitioner's land, and therefore he has sought directions upon the state respondents to construct a retaining wall on the government land. The submission is that earlier also similar orders was issued in WP number 555 of 2009, filed by the present respondent number 4. He has submitted that respondent number 4 in terms of the said order is under a legal obligation to construct the retaining retaining wall on the government land, so as to safeguard the petitioner's property. The writ court, after considering the orders passed earlier in writ petition number 555 of 2009 and the other litigation preceding the present writ petition, has disposed of the writ petition in the following terms. Paragraph 23 to paragraph 26. Full stop. The learned counsel for the petitioner submits that the petitioner is a retired person, does not have the means to construct the boundary wall or demarcation in terms of the liberty granted to him under the order passed in the writ proceedings. To stop. Since in WP 555 of 2009, orders had been passed directing the respondent number 4 to construct the retaining wall, the writ court ought to have issued similar directions. To stop. As taken note of in para 3 of the writ petition, the prayer of the writ petitioner was against the state respondents 1, 2, 3. Full stop. He has not made any prayer for direction upon a private respondent, which we appreciate, since in a writ proceedings, no such direction could have been sought by the writ petitioner. Full stop. Insofar as the reliance placed on WP number 555 of 2009, we consider it apposite to reproduce the said order, full stop, which reads, comma, which reads as follows. From a bare perusal of the order itself, it is apparent that the present respondent number 4 was the writ petitioner therein. He had approached the writ court seeking a direction for disposal of his demarcation case pending before the Tehsildar Port Blair. It is in such background that the court had prevented the respondent number 4 from making any construction till disposal of the demarcation application before the Tehsildar. Only after disposal of such application before the Tehsildar, the writ court held the petitioner would be entitled to, within inverted commas, make such construction as would be found necessary for protecting his building without damaging or endangering the adjacent building. Full stop. The order passed in WP number 555 of 2009 was at the instance of respondent number 4 for fructifying his possession and protecting the lands possessed by him. So the order was not a direction recognizing the present writ petitioner's right to protection of his property. So we therefore find that the submission advanced by the learned counsel for the petitioner that the said was a direction binding upon the respondent number 4, which the writ petitioner could enforce, to be unsustainable in the eyes of law. Full stop. We leave it to the petitioner to avail the benefits of the order passed by the Honorable Single Judge in the present proceedings, as the same has not been assailed by the respondents. Full stop. We find no merit in the appeal. The appeal is dismissed.
And your pleasure.
Yes, please. Can you give us just copies of these 3 orders? Unnecessarily, we'll have to download from the. You give us a copy of these 3 orders. Or you take a copy and then you return it to him. The orders which have to be quoted.
Item number 9, MAT 70 of 2024.
This case, my lord, I am appearing on behalf of the petitioner, my lord, and today I am filing the paper book. And let the matter may be fixed on Monday or Tuesday.
You have served.
Yes.
Writ appeal.
Yes, sir.
Monday.
Right.
As 20 plate. Matter be listed on Monday. Give the date, not Monday, on such and such date. Stop the informal paper book be accepted.
Item number 10,
My lord, I am appearing for the appellant, my lord. I file a memorandum of appeal challenging the order passed by the Honorable Single Judge. My lord has directed me to file the affidavit service yesterday. I filed in the registry, my lord.
Today you have filed it.
Yes, my lord. I spoke to the counsel who is appearing for the writ petitioner. He says, my lord, he has not received, his client has not received that. He says he will accept the copy of the appeal.
Ask him to be here, not today. Tell him.
Yes, my lord.
Yes, not today.
I give an advance copy to him, my lord. So,
If he is appearing, then
complaint.
otherwise we'll see.
Yes.
Not.
Once that proceeding has ended, he will need fresh power. We don't know. Let him be here.
absolutely, absolutely. Blair.
Item number 11. Deputy 2 of 24.
I appear for the respondent.
Directed to prepare the paper books. I required further times 1 week.
What is the matter?
Is the matter very
Specific
peculiar things, Your Lordship. Earlier, we have to file appeal before the district judge with unlimited plenary jurisdiction. But division bench of this court in another matter decided that the district judge has the jurisdiction up to 1,50,000. In another matter, that matter is challenged before the Honorable Apex Court by the party of that case. That is pending before the Apex Court. In the meantime, this case came for hearing and learned appellate court returned my memo of appeal to file before this Honorable. But some matter is sub judice before the Honorable Apex Court as regard the pecuniary jurisdiction.
But you have chosen to approach this forum.
No, I have no other option but to file appeal before this Honorable Court.
So therefore, we will hear the, let us see what is the issue.
Paper book is to be filed, you know.
The trial court records have already been
As per order, it was
I think it
directed
is
to be
there. It
received.
is there.
is there.
Here. It's lying here.
First appeal admission.
It is the first appeal.
Must have been admitted by the registry itself.
That was already.
Already, delay was.
Formal order may not be required also. It's automatic admission. There is any pending application?
No, no, no.
No pending.
Everything is over.
And you are representing the
Respondent.
respondents,
All the,
all.
all the.
Very well, you file your paper book. How much time?
1 week time is required. I already sent for preparation
Learned counsel. You will prepare it outside the court.
outside the.
The learned counsel for the appellant submits that a paper book will be prepared in requisite numbers. A paper book will be prepared in requisite numbers within bracket, typed, copied, or cycloside, and filed after due service upon the learned counsel. You give your appearance.
Yes, I've already given.
MS so and so is representing the respondents. Stop. He needs a week time for doing so. Stop. List after a week.
Another thing is when the second appeal is.
After 1 week.
Another thing is when second appeal is filed, Honorable Division Bench admit the appeal and send for hearing to the single bench. What will be the first appeal? I'm asking myself. That is the technical problem we are facing this due to that order. Asking that.
What is the difficulty? Appellate side rules will not apply.
No,
It applies, Your Lordship.
second appeal.
Therefore, he is saying what is the
Second appeal is admitted by the division bench on the formation of the question of law.
Yes.
But first appeal will be heard by the division bench or single bench, you know, that is I'm asking. myself.
See, that's why we say the answer lies in the appellate side rules. There is no
I will
ambiguity.
come to see and I will place it on next week. One application is also pending in this, I think. Can 3 application is.
We
pending.
just asked you, you said no application is pending.
Can 3 is pending. Yes,
Come with the paper book, we'll see.
Yes.
Item number 12. Deputy one of 22.
After an appeal for the appellant, the registry has prepared the paper book and I received yesterday, Lordship. And I'm able to say whether the other side has been even received the paper book or not, Your Lordship. MP Kamraj. देखिए ना report है देखिए
160 years.
मेरा signature है। नहीं, तो मेरा signature है। देखो ना, कोई दिक्कत होगा तो इन्फॉर्म कर देना मेरे को। हाँ तो वो मेरा ख्याल से वो हो जाएगा उसका। नहीं ये लोग रहता नहीं, जीपी लोग रहता नहीं, पुलिस वाला लोग। हाँ बोल दे बोल दे बोल दे बोल दे। Lordship, in this matter, I am for the appellant, your lordship. The paper book prepared by the registry was served yesterday upon us, your lordship. The other side is not present. So let the matter is, it can be heard out, your lordship. Let the matter be posted in next week, your lordship. Yes, your lordship. Chair. Yes. The copy has been served by the registry, your lordship. So I will just inform the other side counsel, your lordship, has received the copy. So. Lordship, obliged, lordship.
Item number 13, W2022.
I will enter from his.
My lord, this is that public interest litigation, my lord. It appeared before your lordship yesterday, and I was, my lord, directed to take instructions about the completion of the road. Now, my lord, I will, my lord, indicate that the road works are estimated to be completed by the month of May.
Yes.
Now, my lord, the ancillary works may take some time. Those are, my lord, retaining walls, guard walls, and other, my lord, works that may take some time. But the road works, my lord, and we are, my lord, achieving this target also, that the report will indicate itself. And the other 2 points that I was supposed to, my lord, indicate was with regard to, my lord, that was the queries raised by my lord's officers, was regard to BD Nala and RK Nala. Now, my lord, BD Nala, I was informed that yesterday the vehicles have started plying. And so far as RK Nala is concerned, my lord, RK Nala, we will complete the casting within 7 days. But lordship will appreciate, my lord, another 28 odd days are required for, my lord, the strengthening of the concrete. So, my lord, by mid-February, RK Nala will also be operable. So these are, my lord, 3 points instructions which I was, my lord, required to take and place before your lordship. And this is my submission.
Middle State Bridge.
My lord, bridge works are, my lord, that will take some time. That, my lord, we cannot complete by this year. My lord, that in previous reports also we have stated new contractors have been appointed. They have taken the new designs, and my lord, that will take some time. That assessments has to be made.
What have you said about that in your report?
My lord, that we have indicated that it will take at least, my lord, 22 months time.
Just see, where is that in your report?
Not in this report, my lord. This is not in this report. That was the report filed on the prior occasion.
The purpose of filing the present report was to give the court a picture of the present,
roads, my lord.
the present circumstance, the entire from the south till the northern tip. So therefore, that will include the Middle State Bridge.
Yes, my lord, Middle State Bridge, lordship will appreciate, but see.
We have understood what you're trying to say, that there has been some modification in the original design. Contractors change, of course, that is not the court's lookout. You do it from whether you do it.
My lord, not trouble your lordship with those.
That is not the court's concern, and
Absolutely.
that cannot make a pretense for any delay.
Absolutely no, my lord. Lordship will kindly not take it that we are, my lord, putting it as an kind of excuse.
But then what have you said? You must say something that this is the design, this is the amount of time we expect it will take. That must be there before the court. And there was another stretch which was being highlighted by Mr.
Baratang
Kabir.
and Rangat.
Baratang and Rangat. So what have you said about these two?
My lord, these stretch, whatever we have stated, my lord, by completion will be by May, the roads.
Only the bridge is to be excluded from this.
Only the bridge has to be excluded.
So give us.
And there were two issues with regard to, my lord, RK Nala and BD Nala bridge.
We have understood.
That, my lord,
operational RK is in the process.
absolutely, my lord. Mid-February, yes.
Yes. So it appears to be making some, they are making some headway. There's properly not requirement of passing any direction today, but they should come out with a concrete.
So far as the bridge is concerned, I will, my lord, definitely find a report.
Because that last inspection that we had conducted, we were informed that that bridge, they do not expect to be completing anytime before December 2026. That was the estimation we were given in our last inspection. That is in our report that was filed back in June.
No, December 2025.
26, my lord, 26.
My lord, this tender was
22 months.
executed in the month of May 2024. Now, my lord, as per the tender, their tender.
For this bridge.
For bridge.
No, but he says that the tender was issued. There
No,
was some
fresh
problem
tender. Fresh tender in
with the
May
new
20
contract. Okay.
May 2024, fresh tender, 22-month period. My lord, we'll get it from the last order of the 6th December order. There is a period they have set. As per the tender, 18-month for road and 22-month for the bridge.
Yes.
Now,
22 months.
yes, my lord. And when May the tender was executed, that time when we both visited, my lord, they said that since rainy season is going on, we will start the work from December so far as road is concerned, and so far as bridge is concerned, rain is no issue at all. We can continue with the work. This is what they have said. Now, my lord, as per contract also, it is only 22 months so far as bridge is concerned. So from May to May, 12 months, and thereafter, my lord,
No, May they have come out with the NIT.
Completed the NIT.
The work will be assigned. 22 months will
Only from the date the agreement is executed. Then
Was made, my lord, in terms of the orders of the court. Let them say that in May, fresh contractor came to execute the work. We have met the contractor in the month of.
Therefore, there was a submission made by this the learned counsel who is representing NIHDCL. You also say that you gathered information from the site or from officials who were available. In this context, they were required to file a report.
No.
The report does not indicate it.
Well,
Therefore, we are saying let them put it on record.
yes.
Yes, my lord, that will take the stock of the present situation and I will put it on.
Let them put
But
it on
we
record.
not take it as an excuse on our part, my lord, to kind of delay any proceeding or put up any, my lord. Our prime target is to, my lord, complete the work.
This is not an adversarial litigation.
Absolutely, my lord, absolutely. We are all working together, and my lord, we also appreciate the learned officer's effort.
Matter was adjourned yesterday. We have gone through the entire orders. Much headway has been made. There are many problems and which have come in the way. Insofar as the contractors are concerned, speaking for myself, it is not the court's lookout. Which contractor works?
Yes.
We will, can I be responsible?
Absolutely.
Whether they get it done from A, B or C, it
There were
matter.
plans by which the sought to come in, people wanted to join. The court said, look, we are not going to expand this and bring in more and more things. It is between the NH and how they do it. It is their business.
And they must be wanting to do it also. They have an obligation.
There is some degree of progress when the rain stops. That is a submission which we have to make. I'll give an example. When this Birinala
And in their contract also, there must be a force majeure clause.
Yes, that is always there.
It has to be, sir. It is a omnipresent clause in every code.
When that bridge broke, it is a lifeline which goes through the Jaro area to the north. We were in touch with them through the night. Within 4 to 6 hours in the middle of the night, they got in touch with the BRO, with the army. They found the parts. They restored that Bailey bridge. So when they want to do it and they have the materials and infrastructure, they do it.
So it appears now only beyond this Middle Street Bridge is the area of issue, area of concern.
That is the part which has
this
never
side, it has more or less become At least motorable, maybe in a, not in a. up
There's a
to-
very simple reason for saying that. When we first started with this matter, at that time, we had told the honorable bench that there's a lot of technical jargon about this layer, 5 layers of road. So we had said that we will adopt that definition of a road, a finished road, when there is a blacktop covering. But in the meantime, keep it motorable. So
But
we
in
are
between, the blacktop has been found by one of us that,
Yes,
you know, instead
blacktop
of
is-
blacktop, it should be cemented now.
that now there has been a report filed that cementing is not feasible.
Oh, that has come.
That report has come on record.
We have
That's where
communicated this order, my lord, it has found that concrete will, it's not feasible.
December.
This project.
Of December, they have filed a report that it has to be bitumen, this cemented road is different, the layers are different in a seismic zone, it will not last.
Oh,
There are various other considerations. They have experts who've done it. They filed this report on 6th of December. So that is a different thing now. A. B. We have also had experiences where this honorable court has said, let us try and bring in experts from the army, engineers. They also have made it clear that civilian roads and this particular type of thing is not their cup of tea. The thing is very simple, madam. In 6 years, nothing happened because there was one particular contractor who, fortunately or unfortunately, this road was divided into packages. So he was successful in 5 or 6 packages. But he had the infrastructure, men and materials to work on 1 or 2 simultaneously, not all. So some he's done excellent work. But there were these 2 stretches, Baratang and Rangat, which he never touched. Now those in this working season, we are informed that it is under work. So hopefully by May 2025, if this is done, the motorability factor will not be the issue. Then it becomes only maintenance. And the Middle Strait Bridge is one thing which is a wild card in this, because in 6 years, they have built the pillars on either side, but the joining and the connecting parts are not there. Now they've decided a redesign is needed. The reason I'm saying December 26 is because a conservative estimate from May of 2024, 22 months, they are saying they had spent some time in redesign.
The approach is available, only the bridge.
Yes, the approach, they made those pillars, but now they say there's some problem. So
It's
that
over a-
redesign was
It
necessary.
is over a creek, it must be very deep water.
My lord, it is, which is why in between we have seen they have taken those barges.
And what is the span?
The span will be probably between 3 and 3.5 to 4 kilometers in my estimation.
Over the water?
Over the water. The problem right now is there's a ferry. There is a ferry, 2 ferries which are crossing at a time. But those ferries have limited accommodation. If you can have some buses and few cars, or you can have about 10 to 15 cars at best. So what happens is you have vehicles coming at a high speed from Port Blair. Through the convoy, they reach Middle Straits. Then you have a backlog which will wait for 2-3 hours before the ferry can cross them over. Then once you cross to that side, on the Baratang side, the road is miserable. So it's that bottleneck which is creating a problem. That is why the Middle Strait Bridge is key. Is so key. There's another bridge which connects to the Mayabandar side. That bridge, the Azad Hind Fauj Setu, it has proved a complete change for everyone traveling on that highway, because there was the same story of the ferries. And this is open water. This is not even covered water, protected water. This is between 2 islands, a wide span. So it is much more easy for us to discuss and debate it here, but the actual implementation, there is a thing. Now,
Correct, that's why we are saying let them
now
come
we've
out
seen
with-
they have that barges, they bring the barge and they start building the pillars in the middle of the sea itself. 1 or 2 also the construction was going on. Now, when there is such a cost involved and there is such a situation where safety, security is involved, they have reassessed it. The
Safety,
contractors said
security, ecology, all these things.
many
everything
aspects
has-
are there. And in fact, that is why there are so many different factors, like in the Jarwa protection area, the road is the original APWD road, which is being maintained. Now, every time the widening of the road had to be done, there's an issue with the forest clearance ministry. So there are many things.
But from the orders passed earlier, it appears that the present concentration is to have a
Motorable road in the meantime.
Then will come the widening and
Absolutely.
bettering of conditions
Absolutely.
or whatever.
Absolutely. That is why I said that yesterday I was saying there are 2 issues. One is the temporary maintenance of traffic. The second is the permanent solution, which is hopefully coming. Because like I've said before, this is a lifeline. A passenger who gets on from the north, there are some ships, there are helicopter services which may not be easily available to all. But this road is a lifeline.
In the last 2 years, much has been achieved.
And may I say this in all honesty,
one of the bench, even in the last circuit, the matter was heard. Thereafter, his lordship had travelled. After his lordship travelled and came back, his lordship had expressed the view that things are not as bad as perhaps we feel, because there is
Up to which stretch?
all the way.
All the way. All the way it would be how long?
332 kilometers from Chiryatapu at
32 kilometers.
Tamia Bay. The last point is 332
And
kilometers.
one would traverse how many islands in this?
A total of 4, because South Andaman is one island. You will cross South Andaman.
That
starting-
is ends with Middle Strait Bridge.
ends at the Middle Strait River. Then you cross to Baratang. Then you have to traverse Baratang and Rang. Then you will cross Rangat, you will cross, and then you come. Then after that, you cross onto Mayabandar and you head up, and then up into Diglipur. The road at Diglipur town head, I think that is about 280 odd mileage, chainage. From there, the road goes on towards Ariel Bay. There are
I
Navy.
didn't know that you could have such a long motorable stretch here.
The beauty of it is this road was originally constructed by the army long time back. It has been maintained by the APWD all these years. This is what used to be called the Andaman Trunk Road. It has been a subject of a lot of litigation in the Honorable Apex Court. My lord would be aware of the T. N. Godavarman Thirumal
Yes, yes.
forest case.
Yes.
This was one of the main issues with regard to that and the Shekhar Singh Commission matter. So the ATR has been there. The ATR has been there for quite some time. In 2016, it was decided to hand it over to the special vehicle, which is the NHIDCL, to maintain it. Now, from 16 till 22, I may say this with all honesty, the certain stretches were very bad, but
So the
certain
vehicle
stretches were
has
beautiful.
shifted in higher gears in the last 2 years.
Yes, but unfortunately, higher gear vehicle has slowed down.
Again.
Again. Now,
No,
what happens is the working season is like that. You can work perhaps from October, November up till May, June. Once the rain starts, we are also.
Now they say, they have said that by May.
Speaking for myself and not Mr. Binnu also, I would say May 25 is optimistic. May 25, Baratang and Rangat we might see, because the sub-base.
Good to know they have an optimistic outlook to the whole issue.
No, I'll tell you not sure why. Because
That thing we have calculated, because even in November, December, there was some unprecedented incidents of rain which we are not expecting. But we are despite that, we have progressed. This is to our satisfaction also, that we have been progressing in a way so that by May we can achieve the road target. And yes, I should indicate this, that there are certain ancillary works that will take us beyond that period, but that is not just look out.
Yeah, you have said that, we have heard that, yes.
My lord. I'm sorry for the repetition, my lord.
Difficulty with regard to materials, because the quarries that are here produce certain quality of materials. Then there are issues of getting it from the mainland if it's not available. So this court has always said it's for the contractors to figure that out, it's for the NH to figure out. But because materials was a problem, the NH had come up with a new strategy, something which has worked in Europe specifically. They mix a chemical with the soil, and it's something called chemical stabilization. So that by itself forms a whole new base for the road over which you can do your blacktopping. Now that was tried and attempted with 2 or 3 different chemicals over the past few years.
Something by the name of Supermix.
So Sanyal, there are 3 chemicals, but I don't think any of them is super mix, because they are basically from.
That was some chemicals, my lord. I will definitely, it has fallen from your lordship. I will indicate the name, but we have only, my lord, stopped working on that.
The name that I know is Wurtgen, Wurtgen. They make this chemical, and this vehicle, this particular huge big vehicle which moves along the road, it forms a base by itself. Now the miscalculation was with the rainfall in Andamans. Probably doesn't happen in Europe. So this chemical kept failing. Every year they do the chemical and it kept failing. This year they have finally decided to do away with that and return to a more conventional approach, which is why I'm optimistic and hopeful that by May 25 we would see some, because that entire approach has been abandoned.
The matter has been taken up by so many benches that, there has been some shift
My lord.
on various occasions. But it is best in the interest of the present case that there should be a steady course.
Consistency of movement and momentum of work.
Should
So it is better to leave the technicalities and designing and all that and how they will take work from their contractor. This is special purpose vehicle is giving us a time frame.
My lord.
After that time frame, they will, if for some reason they are not able to comply, at least at that stage, the court will be in a position to know
Right.
whether there is a genuine delay or it is general apathy. Because when they come back in May, they will be able to show how much has been done.
My lord.
Absolutely, my lord, absolutely.
The second thing is regarding this Middle Street Bridge, if there is nothing on record, then at least that you should place on record.
My lord, definitely. The entire, as on date, we'll take the stock of the situation and the tentative completion also, my lord, will indicate and file. Definitely we'll do that.
So then today, the only thing we'll do is we'll say that the report is lacking in respect of details regarding Mill Street.
My lord.
Supplementary report before the first Friday of the next circuit, all the
My
issues
lord.
be considered.
Grateful, my lord. I'm extremely grateful.
Heard that, Council.
Sir, regarding my CAN application may be decided, sir. I have submitted a CAN application.
Presenting the parties in terms of the earlier orders passed in the present proceeding. A report has been filed on 6/1/2025. The learned counsels appearing on behalf of the learned special officers as well as the learned counsels appearing on behalf of the parties have in general submitted that the issue regarding the motorable road through the entire stretch has made some headway as a result of the present proceedings, leaving a considerable portion yet to be done. Insofar as the report is submitted, the parties are in agreement that the details regarding Middle Strait Bridge is lacking. Mr. Sanyal, representing the special purpose vehicle NISDCL, submits that the details could not be included in the report since the corporation had to go back to the drawing board. Some redesigning of the proposed bridge was involved. To stop having submitted, so he submits that he would be placing the present status as regards the proposed time frame for completion of the Middle Strait Bridge in between Southern Andaman and South Andaman and Baratang. Let a supplementary report be filed containing the details regarding this stretch of the road. To stop after submission of such report, the matter can be considered in its entirety, including the present report dated 6/1/2025. Matter be listed on the first Friday. It is being listed first Friday of the next circuit. Full stop. Yes.
Sir, I have filed a CAN application that may be decided.
No, but what is according to you the best? All right, then first day of circuit. That will give the circuit some time. All right. Next.
Because I'm appearing for the state respondent, but there is a private respondent. Appellant might not somebody.
Who is the appellant? Not today.
Not today.
As played, not today. See, we wanted to reach the PIL thing, so now we will rise and we'll sit singly.
Your lordship's pleasure to sit immediately or?
Or your lordship will give us an answer. Huh? Whatever. No, nothing. I didn't say that. No, nothing. I have answer question queries. My lord. My lord.
அந்த ஆமா அதுல PVMC.
Any mentioning not in the list?
My lord, I may be permitted to mention, my lord, this matter, my lord, already direction was issued for filing affidavit by the respondents. I am the writ petitioner. The period is already over. 18th November order, 3 weeks time was granted for filing affidavit in opposition. My learned friend is appearing.
Of the respondent, but Port Blair Municipal Council, the direction was against the Tahsildar. The Tahsildar.
They are official respondents.
Sivabalan is appearing for the respondent.
This matter may also be included in the list. This was. It would be coming for the first criminal revision. Unless this court directs, I cannot issue a notice now.
Any mentioning in the list? Item number 1. WPS 720 of 124.
Appearing for the respondent, man.
Your Honor, in this case also, we require time to. Actually,
Break
the advocate in record is not in the court today.
Who are you? You are not the advocate on record.
No, Your Honor. He's also went to the mainland.
What happened? Why is he not here?
He's not well, man.
The council, Mr. Swainso submits, please give your opinion. Mr. Swainso submits that the advocate on record is indisposed. Stop. Not today.
Let it fix on Monday, Your Honor.
All right, as prayed, list on Monday. Give the date, not day.
We are appearing for the respondent.
Please. Mr. Swainso is present on behalf of.
Item number 2. WPS 720 of 124.
None appears on behalf of the petitioner. It's a repetition. None appears on behalf of the petitioner. Full stop. There is also no prayer for accommodation. List after a week. Give the date of Wednesday in all these matters. Wednesday next.
Item number 3. CO 60 of 124.
3 and 4, same advocate is appearing. Advocate on record.
Same order, you give your appearance.
आयुष्य के बिना कैसे आयुष्य को होगा रिप्लाई आया
Item number 5.
My lord, I am
appearing for the petition.
I am appearing for the respondent number 2, but my lord, main respondent is
Indian Oil Corporation
Oil
is the main
Corporation.
respondent, my lord. On the last occasion, my lord, they have not filed affidavit in opposition for a considerable period. This court imposed cost also. Now they have filed their opposition. Even I filed my reply, my lord. But since the learned advocate who is appearing from Calcutta. So we have sent it through speed post yesterday. We don't have their email ID. If they appear, I can take the email ID. The matter may be taken up, my lord.
What have you sent to them?
Affidavit in reply also, my lord. I have sent through speed post yesterday. I have. Because in their
Respond number 2.
respondent number 1. I am
Respondent
for
1 and
number
3.
2.
1 and 3.
1 and 3 is the tendering authority. It's a tender matter.
So
हम लोग को भी कॉपी दे दीजिए
अच्छा आप लोगों को भी चाहिए
दोनों का नहीं दे दीजिए आप व्हाट्सएप पे कर दीजिए
So how to proceed?
My lord, last occasion,
somebody
this
will-
court imposed cost also, so they have filed the opposition. I received the
Yes, sir.
opposition through speed post.
कोई वर्चुअली होगा कोई नहीं चेक
Somebody will be there, I think.
नहीं
My lord, let it be not today because they used to appear through virtual mode, my lord.
Not today.
So that, my lord, it can be taken up in this circuit, my lord.
चलिए मैम नहीं है
If you could intimate your friend that
My lord, I don't know, my lord, because they have, even in their letter, there is no number, my lord. If mobile number is there, I could have sent it through mail. That's why in the address I have sent, my lord, yesterday speed post. Or it may be fixed day after tomorrow by that time.
all right, as State Land Council list on, give the date of the application.
My lord.
You can find out friend's phone number, the lawyer's phone number.
But some lady is appearing, I don't have.
Item number 6. WPS 320/124.
I am appearing for the official respondents,
Same,
Not today, just not today.
not today.
my lord.
In presence of the Land Council for the respondent. In presence of Land Council for the respondent, there is made for not today. So, matter stands adjourned for the day.
And your oblige, my lord.
Please don't give the name of someone who is not here.
Yes.
Only those who are present in court.
No, I was just informing him on whose behalf the request is made.
Okay.
Because both of us are appearing in the
All
matter.
right.
She's leading me. That's
All
why.
Item number 7. I am for the petition. Two matters are there.
You represent all the respondent.
Two matters are there, but similar. One matter is listed in court number 2.
What is it? What is the matter?
Grant of license.
Where is the file?
There is a direction for filing affidavit.
I have already filed for the registry. I got it. Serving the copy to the other side.
But then I am praying time for filing reply.
So what is the status before the apex court?
It is still pending, Miller.
So this order of 12/12/24, it concludes at least one aspect that until the matter is decided, we cannot proceed.
No, one person was granted license.
That is from different list.
No.
I will show you.
No.
Yes. Two
No,
lists
but
were there.
I'll come
The
with
list in which his name is there.
Let us vote.
The petitioner's name is there. It is sub judice before the Honorable Apex Court.
If that be so, this order you have not challenged. This order clearly says
My lord,
that
I
any
just
final decision on the matter can be taken as per final order of the apex court.
My lord,
So therefore, this order is a
inter-party binding.
inter-parties.
I'm not disputing that. Just I received the affidavit.
That I have understood, but the point is, whether you have received, you file a reply, that we can give you liberty. But it should come only after disposal of the matter before the apex court. Otherwise, listing
Nobody
will-
knows, my lord, when it will be disposed.
So we can give you liberty to mention when it is done. Otherwise, this listing is pointless once the court has held that it is to be decided only as per the final order of the apex court. Then listing is meaningless. Nothing is to be done by the court.
I'll come back, my lord, tomorrow, May 6th.
Tomorrow, not today. In presence of so and so for respondent, Same order of prayer is made for not today, matter stands adjourned for the day.
Item number 8.
Lordship, I am appearing on behalf of the writ petition, Lordship. I want to withdraw this writ petition, Lordship.
Please give your, you are the advocate on record.
My junior is there, Lord.
The learned counsel for the writ petitioner submits that he is under instructions to withdraw the writ petition. Stop. Application is dismissed as not pressed.
Obliged, Lord. We are appearing for the respondents.
Respondents are in appearance. They do not oppose the prayer.
Well.
Item number 9.
I pay for the petition, Your Lordship. There was a direction upon the respondents to file their affidavit in opposition.
Because I have been instructed, my lord, we require one more week, my lord, if a week's extension can be. Is ready, my lord, it's just gone for vetting, my lord, 1 week.
Time for filing affidavit in opposition is extended by a week from date as paid by learned counsel for the respondents. Full stop. List in the next available circuit. The time in the meanwhile may be utilized by the petitioner to file a reply if so required.
Item number 10. WPS 6 of 2024 with item number 11.
My lord, Miss Rasi said learned advocate appears for the petitioner. She is not able to conduct this case, my lord, in this circuit due to some personal difficulties. So I pray
As
this
paid
matter.
next circuit. You are for the respondent.
Respondent number 1. My senior.
Mr. So and so is appearing on behalf of respondent number 1. Give your appearances.
Senior name may be recorded.
No, you are here, your name will be recorded.
Actually, he has been appointed by the SLC.
Then we can't say anything. Mr. So and so submits that Mr. So and so is to appear on behalf of the respondents. Why do you leave it? Don't say anything. If he's seeking an adjournment. As prayed by learned counsel for the petitioner, matter is adjourned to the next circuit. Please don't give an appearance of someone who is not appearing. Please don't do it.
Item number 12. WPS 637 of 2024.
My lord, I am appealing for the petition.
I appeal for the private respondent. I was directed to file affidavit in opposition, so
You are filing.
already filed.
You have filed already.
I already filed. I'm serving a copy to the other side. Government has not used. Ask for extension. Because
My lord,
There was a direction for filing a report by the administration. I require some time. It's an old record because the regularization was done on the basis of the pre-1942 encroachers. The case of the.
How many?
Pre-1942 encroachers on the basis.
Pre-1942 encroachers.
Mine.
What is the scheme? I just want to take the opportunity of knowing. What is the scheme?
the persons who were holding land at that relevant point of time, that was in 1942.
Prior
They
to
also
1942.
held, prior to 1942, they also.
Just
held-
occupying.
Yes, they
Not
also
a question
held
of title.
No.
They also held excess land. So after a period of time, the administration thought that because there was an expansion of the family, so these excess land were regularized in their favor.
In the favor of the family member.
Members. Family members. So one of the descendants has come before your honor, your lordship, challenging that allotment, saying that my sister is not entitled because she was physically not present in the land. By virtue of marriage, she has gone to her.
So this issue was not to be adjudicated by any authority.
There was some circular. One circular was issued by the administration that those.
No, that is the scheme.
That is not a scheme, I believe. That was only a circular.
Whatever it is, a policy has been taken. Yes. A thing is to be done in a particular way. If a person raises a grievance, the policy does not contemplate any forum for raising such a grievance.
That representation I have already submitted to the authority concerned.
Representation, is there any authority prescribed for
That is not.
adjudicating such claims? No.
So how to interpret we have.
Under which Is that scheme or policy on record?
Application here.
No, no, page number 15 is the scheme.
15.
Yes.
That's a correspondence. Not a scheme.
This is regarding the excess land.
Yes.
And what about those, the, prior to this, there must be a situation where they were occupying the lands as much as
They were.
they were settled.
Land was occupied.
That settlement was done under which provision? This is only a supplement to that.
No, that
So
was
we
under
can
the
rely-
1929 regularization scheme. That was regulation, 29th regulation.
Yes, anybody?
Regulation.
No.
That the administration can bring if they are having.
Allotment.
This has been issued. 15 July 2003 says that it has come to our knowledge that the area occupied has increased because the family or descendants have increased. Without any premium, we will regularize it. And for this, they say a survey is to be conducted. So they obviously all this survey and all must be specified in the earlier scheme.
That I can bring.
No. But prior to this excess lands for settlement of the lands, there must have been a survey conducted. So under which provision it has been
The
done?
administration will be able to justify.
Unless we know how are we to proceed, because they will probably be relying on clause small Roman 1, which says that it has to be an occupation of the descendants.
The occupation.
Clause number 2.
So the only basis to arrive at a conclusion regarding this dispute will be the survey conducted by the authorities. Now
The
that,
intention behind introducing this particular clauses, we have to see in that context also.
no, but if that is one aspect, you are correct. The other aspect is that the survey must have, it says to conduct a survey. That means the procedure is already prescribed earlier. So what is the survey? During survey, was there any scope for objection? Was there any authority to consider? These things have
Respondent can highlight.
Called for.
Government
Claims and objections were called for
Called
by
for.
way of advertising.
Which provisions?
My lord, there was this Government of India scheme specific.
This is
like
what
for
the court
those
wants to see.
Landless people. Who
Yes.
were not allotted with a particular landed property. For those persons, one scheme was formulated, my lord, by the Government of India for specific persons like who don't have any landed property in these islands.
That is in respect to 1987 scheme. Now it is 2003 scheme with a different.
87, 29, 2003, but we don't know where is the scheme. You are giving dates out of the pocket, out of the hat. We want. Let us see what the
1987 scheme says that
That was a
the landless person who occupied the government revenue land, Badi land, prior to 1978, 31st
You are
December.
the person claiming that the sister should not be granted.
Yes. Because the scheme says who descendants who is in occupation of subject landed property. I am maintaining the occupation position.
You may be, but in the survey, they have found her to be in occupation.
No survey was conducted.
Because
That is the
how
reason.
the allotment was done. It was
Yes,
done by.
Where have you stated that no survey was conducted? Let us see this statement. Where have you made this statement?
The license was issued in 2008.
Just wait, let him show he is making a submission. He must have pleaded, then only he must be submitted.
Paragraph 8 I have stated.
You are saying carry out a survey and found that the petitioner and his brother.
Yes.
And here you are saying no survey was conducted. The contrary of your client's statement on affidavit, you are submitting as a counsel. Very unique circumstance, sir.
No, no, my lord.
You just now said no survey was conducted. And your client says that survey was conducted.
Subsequently.
You did not say subsequently or previously. You said after 2003 not done, and here he says under the regularization scheme of 2003 survey was conducted. This is not expected.
Survey means the demarcation.
Please don't try to now just somehow justify your submission made contrary to the record.
Occupation, who are in occupation of the subject land, that survey was not.
No. You said no survey was conducted. That was a incorrect statement.
Two things are there.
That was an incorrect statement.
Two things are there, my.
Please don't try to push it. Don't try to push it. That is not expected from any counsel. I want to believe on what you say. I don't want to have to check every line from the record, whether a counsel is saying the correct thing or not. This is not the way. How can you make such a submission contrary to your client's statement? You cannot make out a third case as a counsel. So that is not the issue. What is your grievance? Let us see.
What happened, my lord? Here initially the authority has been directed to produce a report. Whether any survey was conducted or not.
There is a question of report. You have yourself said that survey was conducted.
This honorable court directed the authority.
All right, that was an interim order. We are looking at it now.
My lord,
yes.
Scheme, the first clause of the scheme says that if the encroachment has been done prior to 1961 and the descendants are who are in occupation of that certain landed property, the regulation should be done in their favor. Now, I myself and my elder brother was in occupation of that landed property. But the name of my sister who got married in the year 1974, her name was also incorporated. But name was also wrongly incorporated, Meena Bai or something. And I made a representation that her name should be deleted from the record. Because as per the scheme, who are in occupation, they are entitled to get regularization.
So where is your sister's name is appearing in the record of rights in which page?
Pujari.
Page 17.
Page 18 also.
No. Oh, yes. Page 18.
17.
The right, your lordship will find excess land, excess area regularized by the RC number such and such, approved by the competent authority. This one is done way back in the year 2008.
And that was not challenged.
That was not challenged.
Then why did you not challenge this revenue case?
The name
order passed in AC.
Name was incorrectly recorded in the license.
So therefore you are required to challenge it.
Representation to the authority.
The
And subsequently it was going on for correction of name. Name has been corrected subsequently. Page number 18 is the present record.
No, there also our name is appearing.
Yes, name is appearing. My name has been corrected.
His name
And
is
the name of
wrong.
my elder brother has been corrected. Initially, my name has been recorded as Hari Narayan.
So you asked for a correction of the name that has been done.
Thereafter, I made a representation, which is at page number 20.
But he has not.
And I have stated all the facts in my representation.
You were required to assail the revenue case order passed in 2008. If you have not done that, how can it have been done? Cannot be done. 16 years after the entry is made, you write a representation that you delete it. And knowing that it was there, you have got the corrections done much earlier. You have not raised any objection. Where is the question now?
Names.
It was within his knowledge.
It took number of years to correct the names in the record.
We don't know.
Even
We don't know. How can you? You cannot. You have not challenged the order passed in this RC case. What report? No report is required. What is the report required? What will the report? Report for what? What detail do you want in the report?
no, I didn't seek any report. This
No, you
honorable
said
court
that
directed the
there's
honorable
no
court
question
directed-
of filing any report.
Honorable court directed the authority to file a report.
You don't even give the detail when she was married. In your representation, you have made a sketchy grievance saying that she cannot be included because she is married and she is not in continued occupation, whether she was married at 2003 when the scheme came, or she was married when the RC case was decided in 2008, or she has been married in 2022. Nobody knows. Such vague assertions,
40 years of age.
whatever it is, we don't know. This is just appears to be a attempt to somehow exclude her. When was she married? When did she cease to have occupation? Where is this fact?
I have stated.
Let us see where you have said. Where is the settlement scheme? Anyone of you can you show the settlement scheme?
Fine.
Show it, then we'll take up this matter. You are representing the administration, counsel for the administration. Should place before the court the policy stroke decision under which the 39042 settlers were regularized. Stop. Let the matter be taken up on, give the date of Friday. We're giving you 2 days. Yes.
Paragraph 4 of my writ petition, I have stated when she got married in
What
the year
you have-
1966. Paragraph 3.
Only let us see what is the scheme.
Item number 13, WPS 640 of 2024.
I pay for respondent authorities. I seek 1 week's extension of time to file affidavit.
Opposition.
No, affidavit, report in the form of affidavit. There was a direction on 11th of previous month.
Vote for what?
There are several grounds of attack to the order impugned. One of the primary ground is, Lordship, the adverse report, which was the basis on which the decision was taken, was not given to me. There is an audio alterum partum violation. This court, while entertaining the writ application, directed them to submit that report, alleged report, based on which the decision was taken. Now they want to bring that report by way of an affidavit. If I'm not
Already there is a direction on 11th of December.
Which report?
report, Lordship, it's an adverse report. Lord Cali turns to the impugned order once, Lord would find certain reports were relied, which were collected behind my back to come to an adverse decision. Lord, I'll just take Lord's to the
Impugned order is 6/11/24.
Yes, Lord, 6 November 2024 at page 68 of the petition. Lord would find at the first opening paragraph of the impugned order, Lord would see that whereas Tasla Mayavandar has reported that one Sri Rama, Lakshmi and M. Ahmed have illegally diverted land bearing survey number 42, area 1.380 hectares classified as paddy 2 situated at Latao village by way of using commercial purpose. This is the one report, and the Malad would find 5th paragraph in the same page. There is a second report being procured based on which the impugned decision was taken. I have taken my specific ground, Lordship. Since this adverse report were collected behind my back, a copy was not given to me. There is a flagrant violation of principle of natural justice. This is one of the ground. So these courts said you just bring those reports on record so that the matter can be decided finally.
Where's your reply to the show cause?
It's one would find it's at page 65 to the writ petition.
The fact that it was not diverted is admitted by you in paragraph 7 of your own application. The fact that it was not diverted as a commercial land, it is admitted by you.
No, this is a clear admission, but they have collected certain report to take an adverse decision that I have used the plot for some other purpose.
No, they say you have diverted it for commercial without any permission.
This finding is based on those alleged reports.
But that is an admitted position by you. Where is the question of any audio alterum partum here?
This reply was filed, then the.
Please read para 7 of your.
My lord.
Reply.
Para 7, I'm just at page, my lord.
Page 66. Yes.
That thereafter again, the OPC, M. Ahmed, K. Shanmugam and others have applied for diversion of land bearing survey number 42. And RC case was registered being RC number so and so, but the land has not yet been diverted. But under the regulation, special law, I have to obtain a diversion permission.
Which you have not obtained.
No, I have applied for it.
It was not obtained. That is what we are saying. You have applied, admitted position, not obtained. And that is the report. So what is the prejudice?
But they have kept my application and animation suspended animation.
That is a different aspect. Whether you have not approached the court for a direction to expedite these proceedings.
No, Lord.
You are saying that this order. There is no question of any prejudice being caused by non-supply of the report when the admitted position is that it has not been diverted.
It's true, Lordship. And then, but there are other grounds. Jurisdiction ground is also there. The authority who passed the order impugned has no authority under the regulation to pass it.
Let's see.
No,
to that.
my client turns to the regulation, Lord.
Yes.
LR, this is Andaman and Nicobar Island, a land revenue and land reform regulation 1966.
Page?
Book, Lord needs to see the book, it's a regulation, special regulation, which is governing the entire affairs.
Yes.
Lord kindly turns to regulation 151, my lord would find this at page
Yes, I have it at page 28.
28, Lord. I'm just placing it now. A tenant shall be liable to be ejected from his holding by an order of subdivision officer made on any of the following grounds. Namely, A, he has done any act which is destructive or permanent injurious to the land comprising the holding, or he has used such land for any purpose other than for which it was given, or he has transferred his interest in such land in contravention of the provision of regulation or rules made thereunder. Subsection.
It is within the jurisdiction of the subdivisional officer.
No, Lord. But under regulation 157, my lord, kindly
157.
I can improve my landed property, my lord. See, there are division bench order of this code defining and interpreting this definition 157 regulation.
No. Improvement for better cultivation is a different thing.
My lord.
Changing the nature of use from cultivation to commercial is a different.
It was never changed, my lord. That's
what you are admitting in paragraph 7.
It was not diverted, but I have not used it. The purpose for which it was granted to me, I am using for that only. Not kindly.
All right. In your representation, where have you said that the user has not changed?
Just 1 second. Lord.
Yes. So you say we applied it, not diverted, but we continue to use it for cultivation purpose.
The purpose for which it was granted.
Where is that? Let us see.
Let me.
But if it is for cultivation purpose, why will you construct a concrete slab?
No, Lord would see regulation 157. I have to improve my landed property. I can raise the building. The language Lord would see it's raising a building is within the ambit of regulation 157. I can do so, Lord. But the authority takes a decision, Lord should know. You have
no, in which 157, which
subclause? Regulation 157. My lord would see a tenant shall be entitled to make any improvement in his holding for better cultivation of land or its more convenient use. Now, can it turns to the definition clause at the very initial pages, definition clause, improvement has been defined. It's regulation 2, sub-regulation 12 at first page.
Sorry?
First page of the regulation, Lord would see regulation 2, sub-regulation 12 at the bottom. Improvement has been defined. Improvement in relation to a holding means any work which materially adds
consistent with the purpose. Therefore, we are saying it has to be consistent with the purpose. And the purpose was cultivation. You are admitting that you have constructed a concrete slab. How can a concrete slab facilitate or in any way improve the purpose of cultivation?
No, definition of improvement includes raising of building also, Lord.
But that definition you have just
within its fold.
You have just now read the definition.
Yes, my Lord. No, kind turns to the next page to the improvement. If I raise a building for the better cultivation, it's within my ambit. I can do so, Lord. It's not that there is a total bar. I can raise a building. But there is an exception in carved out that these works I cannot do it. But raising of the building is well.
Where is the exception? What you are prevented from doing? Take your time. Don't be. I want to familiarize myself. That's why we are.
Yes, no, kindly be a member. Lord, it's sub rule small Roman 3 at page 2. Erection of buildings on or in vicinity of holding elsewhere than
that we have. I have seen subclause 4.
My lord,
not 2.
Subclause 4. Yes, my lord.
That's not 2. That's 4.
Yeah, I'm sorry.
That I have seen.
Yes,
but you just now you were saying something else.
My point is, my lord, for the purpose of improvement, I have raised the building.
No, but you said there are certain exceptions which one cannot do. So I asked you, where are those exceptions?
Yes, it's down below, Lord, but does not include. Lord would say, Lord goes little.
Yes, 5.
Yes, Lord, 5. 5 and then does not include the construction of temporary wells and such water wells, embankment, level enclosures or the other works or petty alteration in or repairs to such works.
Yes, you give the
These
report.
works I cannot do it.
You give the report, yes.
These works I cannot do it. But structure I can raise it at any time.
The land counsel for the petitioner submits that the petitioner had sought diversion of the land use purpose, which is still pending before the concerned authority. To stop in the meantime, based on a report, copy of which was not supplied to him in the proceedings arising out of RC number 30 stroke capital AC within bracket HQ stroke MB stroke 2024 stroke 306. The subdivisional officer has Mayabandar has given a direction to remove the illegally constructed building within 7 days, comma, a full stop. It is submitted that the building has been constructed in the vicinity of the agricultural holding with a view to its improvement in view of the provisions contained in the Andaman and Nicobar Islands Land Revenue and Land Reforms Regulation 1966. To stop, it is specifically submitted by the learned counsel for the petitioner that the petitioner is not carrying out any commercial activity from the lands in question. Stop. It is thus submitted that the report of the Tehsildar Mayabandar, relying on which the subdivisional officer has passed the impugned order dated 6/11/24, without serving a copy of the same on the petitioner, is unsustainable. Stop. The learned counsel for the respondent submits that an affidavit in opposition will be filed, bringing on record all the details, including the report submitted by the Tehsildar Mayabandar. Stop. The time for filing affidavit in opposition is extended further by a week from date. This thereafter.
There is an interim order operating that need to be extended.
No, there is no interim order.
By the first order by Justice. The demolition part has been stayed from its operation. Which has been directed by consumer.
Order. The interim order contained in the earlier order dated 13/11/2024 stands extended till 15th February.
Highly obliged, my lord.
This you send home. This one. Is there a copy at the residence? All right. Then
Forest.
Item number 43.
I appear for respond number 2, my lord.
1, 3, and 4. Muniang.
Item number 40. The previous 647 of 2024.
I'm there for the.
I pay for response number 2, my lord.
I'm for 1, 3 and 4, my lord.
Not filed. Have not been served with the copy.
File the report.
Just this has been, these papers has been handed over to me just now, Lord. Let me go through it and I'll take exception to the report.
You have also filed, both respondents.
Response number 2 have filed the report.
You are on behalf of,
Response number 2, Forest Department.
and you are on behalf of the administration. So you have also filed. Right.
So because it's regarding the forest.
All right. So
land.
contesting respondent has filed.
Yes, contesting.
The respondent number 2 has filed an affidavit in opposition. The copy has been served today to stop the petitioner's counsel. Appellant's counsel seeks, it's a writ petition.
It's a writ application.
These two matters also similar matters in the Supreme, these matters are pending before.
Is it?
Yes, my lord.
Yes.
Based on a
I have
decision
gone
of the
through
Supreme
report.
Court, a policy decision was taken by the administration. Those who are found encroaching in forest land have to be adjusted somewhere else. So a decision was mooted out, my case was recommended. Based on a decision of the Supreme Court, the things have been moving. It's not that there is a list pending before the Supreme Court. It's not that.
As per the report, my lord, just I have gone through the report. It has been mentioned that it is the same list of 89 encroaches which are before the Honorable Supreme Court. The subject is before the Honorable Supreme Court.
Then how can we proceed? We cannot.
It's not the fact. It's not borne by record, Ashok. What matter is saying, it is being brought on record.
Report.
Let it be brought on record.
In which report?
I'll go through it.
We have filed.
For today you have filed.
No, on the US, we have filed in the registry.
Today you have served a copy, na? So let him, yes.
Let him take an exception to that.
The learned counsel for the applicant wants to file a reply, stop the same be done within a week,
Yes, month.
list thereafter. We can take it up.
Next week, let it come, Lord. Let it retain in the list in the next.
All right, next week. Give a date of Wednesday.
Month.
Next matter.
Same mixed matters also.
Same.
Who is appearing?
We have
Same position.
Yes, same position.
All right,
Same
same order.
Same.
Item number 16. UPS 16/24.
I'm for the respondent here.
Petitioner, my lord. The petitioner, senior citizen, he made a complaint. While he comes to page number 17. Senior citizen, certificate was enclosed.
Where is the complaint? What complaint?
Okay, my colleague come to my lord,
Page 19.
page number 22.
Huh?
On my complaint is proceeding initiated by the sub-divisional magistrate. Page number 22. But till date, it has not been completed, it's pending. So pay for direction for the sub-divisional magistrate to conclude the proceeding in a time frame.
When have you filed it?
My lord,
When did you file it? October 23.
my lord. It's at page number October 9th, October 23, page number 90.
Page 22, my lord, we have already initiated the proceeding, my lord. On the
Let
complaint.
them conclude the proceedings, it's pending. They have not concluded it.
A complaint of October 23, you initiate proceeding in August 2024. After 10 months. Prior to this, nothing. When was it received? Yes, 12/10/23.
I think because the complaint is received from Shivra. Your lordship have seen, you know, the first.
Yes, sir.
There is a complaint letter has been received from Shivra.
Who is Shivram?
Son, that's my son.
Then where is that complaint which he has submitted?
Page 23.
23, my lord.
No, where is Shivram's complaint?
Shivram's complaint is not there.
But
He is not
Complaint of
son, he is
petition.
son-in-law.
Shivram complaint is not there.
son, not son is.
All along the
Oh,
complaint that has been given by Jamuna Devi.
She's my mother.
that I have understood.
My lord.
The complaint has been filed by one Shivram,
My lord.
and that is the document you are relying upon. So
My-
where is that complaint? When has he filed it?
That complaint is not.
If he has filed in August 24 and it has been initiated, what is the delay? There is no delay. We don't know. We don't even know what the complaint is.
Shivram's complaint, it seems, my lord, for illegally damaging the compound wall situated at Naya.
Where is that complaint?
It is in the.
Yes, in the order of the subdivisional
Yes.
magistrate, it is
It
mentioned.
is mentioned. But complaint is not there in the writ petition. It is not annexed with the writ petition.
Your complaint is something different, that he is cooking in front of your house.
Yeah.
This is not a complaint.
Page 22 is different.
In
It
page
is a different
23, I
complaint.
mentioned that they're constructing the damaging the wall.
You have not mentioned, we don't know.
My lord.
There is no coordination between these. We don't even know whether she has filed a complaint or not.
Her complaint is there at page number 23.
That's not her complaint, sir. Sorry.
Page number
That is to the Tehsildar. Tehsildar is the competent authority.
For obstruction of the footpath is the authority. 104
It
regulation.
is filed on 3rd January 24. But,
Or no, suggest one thing, Lord. That assembly Tahsildar to dispose of
This is under which provision? You filed under which provision?
which were page number 23.
Yes,
104 regulation 104 is there.
regulation 104.
104. If any obstruction is there.
No, 104 is,
Any obstruction, footpath obstructions is there, then you can remove it with Tahsildar. First part, Lord, first. The rules, second part, rules, first is the regulation.
third January 24.
Right.
What steps you are, who is for the Tehsildar? You are,
I'm for this.
what steps have you taken? Respond number? Tehsildar is respond number?
Mine. Respond number 3, my lord.
One 104 has to be after issuing notice.
Private respondent is also there, my lord.
You are appearing. You will appear before the authority, the land council, yes, the land council for the petitioner submits that the petitioner is a senior citizen. Stop, she has complained that the private party respondent number 4 has made some constructions on the road side of ward number 12 at Nayagaon in Port Blair, regarding which intimation has been given to the Tehsildar of Port Blair on 3rd January 2024. Stop, in spite of such intimation stroke complaint being made, the Tehsildar has yet to proceed in the matter in terms of Regulation 104 of the Andaman and Nicobar Islands Land Revenue and Land Reforms Regulation 1996. The change. The respondent number 4 is represented in today's proceedings to stop the parties. When will you appear? Give a date, any agreed date. No, you give a date. 2 weeks, 3 weeks, whenever.
4 weeks. This is week.
No, when you will appear.
After 15th.
After 15th. The respondent counsel for respondent number 4 submits that the respondent shall enter appearance before the Tehsildar Port Blair by 17/1/2025. Full stop. Since the parties have agreed to pursue the remedy before the Tehsildar Port Blair, no specific direction is required to be passed in the present proceedings, except to observe that it is expected the proceedings would be completed by the Tehsildar Port Blair expeditiously without unnecessary adjournments or undue delay. To stop, the writ petition stands disposed of.
Obliged.
Complete.
Article number 70, WPS 657 of 124.
I have a writ petition.
And for the respondents.
The petitioner is the joint record tenant of the particular piece of land at page number 90. Name appears at record of right holding register at page number 90. Then he made an application to the Tehsildar for valuation certificate, page number 27, online on 14th March 2024. But till date, they have not issued the value certificate. Whereas they issued the note use, no comes at page number 28, but they have not issued the value certificate to my client.
You are Sunil Mandal.
I'm Sunil Mandal.
So what is this valuation is?
For selling my land, I need the valuation certificate from the authorities concerned because it's a recorded tenant. Without the valuation, I cannot sell it.
So there is no forum of where you can raise the grievance if
No, there is no forum here.
It is application before?
No, to the deputy commissioner. It is mentioned. I applied to Tehsildar, it has forward to deputy commissioner. Bottom panel see, man. The status application forward to deputy commissioner, DC.
He is respond number?
Respond number, my lord.
One.
One. Why he is sitting over the matter?
Take instructions since it's a matter related to Mayavanda Tehsil.
Yeah.
So.
To find out, inform the court.
Hello, this matter will be fixed on Monday, my lord.
All right.
I'll take it.
The petitioner's request for a valuation certificate was forwarded to the respondent number 1 as far back as on 14th of March 2024. Full stop. He complains that till date, the certificate has not been issued. The Land Council for the respondent submits that she will be taking instructions. Full stop. Since the issue is only of issuing a valuation certificate, it is expected that the Land State Council, you produce it, what is to be done? Ask him to do it. What is the big deal? Land State Council should ask the respondent number 1, should seek instructions from the respondent number 1 as to the final decision taken in respect of the petitioner's claim. To stop, let the same be submitted. And the matter is taken up next on, give the date of Monday.
Great.
Number 18.
Sir, I have filed this writ petition. I have made 3 parties. Actually, sir, I am a 2024 Lok Sabha MP candidate from Andaman and Nicobar Island. On the for 90 days of campaigning, I got around 8,500 votes. Sir, in this matter, my YouTube channel, which I use for spreading social message and political message, and it is my personal account, which has been deactivated or terminated by YouTube without any valid reason. Sir, it is there is no copyright law violation. Even then, it has been deactivated. So what I want is that an order may be passed directing them to activate the Sage account as soon as possible.
Directing a private entity.
No, sir. Actually, there is a Supreme Court judgment which says that when a YouTube is carrying out private, like public function, it cannot act against the individual, because there are many orders also. I have read, and accordingly I have drafted this petition on my own, because as you know that no advocate is willing to appear on my behalf, so I will be forced. So there are proper grounds which I have give in this petition, that on what grounds that can be activated. YouTube is performing public function. It is not my statement, it is the Supreme Court statement which says, because there are many instances that where the YouTube have deactivated the accounts of those who are criticizing the present government. So in that case, you can dismiss the petition, sir, if you want, because what I want is that I found that there is a valid ground, so I have submitted this petition, sir.
What is the grievance? Your account has been deactivated.
Yes, sir. Yes, sir. Without any reason that they say that there is a copyright law violation and all, because there is no copyright law violation, because I have made a small clip I have used of the former Lok Sabha MP, Vishnu Purwai, and I added comments to it.
I've already heard thrice since morning that you were a Lok Sabha candidate.
Yes.
That affect the merits of your claim. What is the order whereby they say that assigning the reason for deactivating your account?
So they say that there is a copyright law violation.
What is that? Which page?
One second. Sir, annexure P8, you can see annexure P8.
Can you give the page number, please?
42, sir. Page number 42. 41, 42. Sir, I have shared a video clip, which is the MP candidate of Lok Sabha MP candidate of BJP, which added comments.
Did you file the counter notification? Did you submit a counter notification?
Sir, yes, I have sent the counter notification. Yes, I have sent.
Where is that copy of your counter notification?
Sir, P9, Annexure P9. I have sent 2-3 times, sir. There are many from P9, all 51, 52, 53, 54, all my counter notification. You can see 54 also page number.
No, you were required to submit a counter notification. You could
Yes.
file an appeal by submitting a counter notification.
Sir, that's what I have 3 to 4 times I have sent counter. All the annexures are there, sir, from P9 to P10, all are counter notifications.
Nine. A page, please. Your paging is not done properly.
Page number, no, sir, page number 54, 55, 56, you can see. Page number 56, you can see, sir. Page number 56. Page number 56.
It was within the 7 days.
Yes, sir, either within the 7 days. Sir, 2-3 times I have sent, sir. 2-3 times you can send, sir. I have sent many times, but I have received no response. So I have submitted this petition before this court. And all the 3 videos we have submitted, it is against the BJP central government.
Manoj, may I assist, Manoj?
Just a minute.
Please.
This is not apparently not at the instance of YouTube. You have used a clip over which somebody is claiming a copyright.
Yes, sir. There is, sir. The Copyright Act says when you upload a clip, video clip with added commentary, with added opinion, then it won't fall under the copyright violation. It is the YouTube itself says so. So I have with added commentary, I have uploaded that video with that clip. So that is the reason it won't fall under the copyright violation. Because it is a statement made by the BJP MP, present BJP MP Vishnupada Roy. So I made that he is trying to settle outsiders at Andaman Nicobar Island, which will be affect the local residents, including the tribals. There is no violation of the Copyright Act. In the page number 56, I have explained properly, sir.
Yes, you are appearing for Mr.
Because I'm trying to respond number 1, Milos. That says, Milos, he has implemented Google India, Milos. First and foremost, Milos, Google India is not the correct entity, Milos. It is Google LLC which provides the platform, Milos. That is youtube.com. That's in first and foremost, Milos. With respect to the other thing, Milos, the maintainability is an issue, Milos. It's a private list between him and me. So, Milos, it has to be, the writ per se would not be maintainable against. So that is my preliminary objection to that.
But he is given an assurance that he will not do this in future.
Milos, it is now, Milos has rightly pointed out that Milos, these strikes were made by third party Milos, who are the content owner Milos. That is, one is News Andaman 24/7 Milos, and the other is Red Chili Entertainment Milos. So it was their copyright which they had made the strikes Milos, basis that we had acted. So Milos, who are not party to the present right Milos. So in whichever case Milos is aware that I am an intermediary platform Milos under the Information Technology Act. So Milos, in that is one thing Milos. So he has to, in any case, they has to implead them Milos. It's a out and out issue with respect to both the parties who have made those strikes Milos. It has to who have to be heard Milos, who are not party Milos, and all the reliefs are sought against me Milos as a private entity Milos.
Because the Google is then, sir, parent company of
I
YouTube.
don't perform any public function, because I just merely provide a platform, because he can go to any other platform, because I have no difficulty.
So
There is
the
no public function, because just it
claiming
is,
copyright violation has not been made a party.
please, Milos, the copyright owners have not been made a party to.
Oh, why, Mr. Paul, you have not, why have you not implemented them? How can anything be decided in their absence?
Sir, actually, sir, oh, okay, you are saying that private party who have made the copyright claim against me.
Yes, it is on their complaint that the action has been taken. How can it be done without hearing them?
Okay,
The-
sir, then.
Yes.
Then I'll act as a party, sir. If this court wants, then I'll act them as a party, no issue.
The learned counsel for the writ, and you are in person, the writ petitioner in person,
Yes, sir, I'm in person.
being faced with some difficulty, submits that he would be impleading the private parties claiming copyright of the material uploaded by him, comma, forming the basis of deactivation of his account, of his YouTube channel, full stop.
Please.
The such submission has to be considered keeping in background the issue of the preliminary issue of maintainability of the present writ proceedings raised by the learned counsel representing the respondent number 1.
Please.
In the same breath, it is submitted by Mr. So-and-so representing the respondent number 1 that the respondent number 1 has incorrectly been described in the writ petition, full stop. Let the learned counsel for the petitioner take appropriate steps in this regard also while filing a petition for impleadment of the other private party respondents, full stop. The reserving the right of the respondent number 1 to contest the issue of preliminary issue of maintainability. The is adjourned. How much time you will take for filing the?
Sir, please don't adjourn for a long time, because 14th I am coming to Portland. By 14th it will be filed.
You
Can
will
approve.
why are you making this submission? How much time?
Sir, just 15. Fix the date on 15. By 15 I'll submit everything, all documents.
Stop. Let the matter now appear
On 15th of this month, sir.
on 17th.
Thank you, sir.
Let advance copy of the application be served on the council representing respondent number 1.
Sure, sir. Thank you.
Grateful.
Grateful, Milos.
WBS 619 of 2024.
My lord, in this matter, bring for the petitioner.
Yes.
Copy has been served upon all the respondents.
Yes, what is your grievance?
My grievance, my lord, the petitioner decision have been issued with the license to occupy the agricultural land, piece and parcel of agricultural land. So now they are in the positions, the position of the particular land which has been issued through license. And so in terms of the license, they should also be in position of the record of rights and the sketch mapping. So which has not been issued. In spite of several requests and representations, it has not been issued. So they have made a representation several times and also approached the authority, but it was not done till date, my lord. So, but they have taken the steps.
How can you join so many persons in one writ petition? They are all seeking a separate relief. It is not that the relief can be granted by one stroke of pen. They all have to be issued the relief separately. You have joined them in a one writ petition. How it can be done?
Except the response.
They all have different dates of regularization. They will all have their individual claims. Order will have to be issued for them separately. Where is the commonality? How many petitioners you have completed?
Only a single petition.
Huh? There's only one.
One.
Oh, yes. There is one. What have you asked them for? Sketch map?
For record of rights and sketch map.
Where have you asked them?
My page number 27, my lord. My recommendation dated 21st March 2023. So in response to my recommendations, they also they have done the process to supply the record of rights and the sketch map, and they have seek some information from the concerned tehsildar. My lord, but after that, no steps have been taken now. Still, it is pending. I have personally approached the petitioner personally approached, but it was not done, my lord. They have the tehsildar settlement seek assessment for the premium, from the tehsildar Farganj, which jurisdiction this land falls. My praise, it may be disposed of, and because in the similar matter, my lord, I have annexed the judgment of this honorable court, where my application was disposed with the direction upon the official respondent to supply the record of rights and it has been complied now. The similar nature of cases. It's in page number 31. It's order of Honorable High Court. Thereafter, it has been complied with. After all due process.
Who has to do it?
The Assistant Commissioner Settlement. License has been issued by the Assistant Commissioner Settlement by the order of the respondent number 1, Lieutenant Governor.
What has been issued?
Record of rights and sketch map, the subject line.
Record of rights and assessment of the revenue.
I'm ready to pay the premium if it is required. It's required. So I may be supply with this record of rights and map. Because the tehsildar, this particular land has not been recorded in the revenue records of the tehsildar. In terms of the license, I should be given the record of rights.
Where is your license?
It's in page number 25, my lord. The rate application. The additional deceased husband.
Why do you require this assessment or sketch map?
Sort of in terms of the provisions of LLR, Andaman Nicobar Land Revenue, the section the tehsildar should also maintain the record of rights.
Under?
The section 77 of the Andaman Nicobar Land Revenue and Land Reform Acts.
Yes.
Which I have quoted in my writ application. So they should maintain the record of rights and sketch map, and it has to be supplied to the license holder. Section 77, section 82, it's all pertaining to this record of rights.
Because the amount of license revenue is already specified in the license. Land revenue is 4.94
It's my prayer, to supply me the record of rights which I did not have, because the assessor has to maintain the record of rights and for each allotted land.
He has to maintain, but he has to give you. Where is that requirement? That is what we are trying to say. He's maintaining and he's giving to
I
you.
prayed for the record of rights where they did not supply me. I prayed that my record of rights in the sketch.
Where do you have the right to seek such a? That is what I'm
Yeah,
saying.
this is there, I put it in my great application, a particular provision. That is section 71 of Andaman Nicobar Land Revenue Land Reform Act.
71.
77 clause 1. The assessment fixed under section 75 shall be the land revenue payable annually on such plot number unless as it is modified in accordance with the previous provisions of this regulation. Section 82 said that there shall be prepared by the prescribed authority a map showing the boundaries of the survey numbers or plot numbers and waste land called the field maps for every village except when otherwise directed by the chief commissioner. Section 83 says the record of rights in accordance with the rules made under these regulations be prepared and maintained for every and such regard. Such includes the following particular, namely the name of the tenants together, the nature and extent of the respective interest of such persons, the land revenue payable by each person. And even section 92 clause 1 provides that every person whose rights, interest or liabilities are required to be or have been entered in any record or register under this chapter shall be bound on requisition in writing by any revenue officer engaged in complying or revising the record or register to furnish or produce for his inspection. Within 1 month from the date of such requisition, all such information or document needed for the corrections, compilations of revision thereof as may be within this knowledge or possessions of our. And section 94 is important, my lord, which provides that the certificate copies of the entries in the records may be granted by such officer on payment of such fees as may be prescribed. Your Honor. So I have the right, Your Honor, to have the copy of the record of rights in my possession. Since I'm in possession, by virtue of that license, I'm in possession of the agricultural land. Your Honor.
What fee have you paid? Where is the fee?
Because see the record, they are not, the assessors supposed to be in the possession, in the custody of all the record of rights of the allotted land. So,
See,
so
you
it is not available.
You are asking for a copy of the assessment and the revenue amount
Record of rights and sketch map, Your Honor. For that, I am ready to pay the requisite fee.
But then you have not applied in terms of regulation 94. 94 says it can be granted on payment of fee as may
And
be
we come to the page number 26, Your Honor. The press note, Your Honor, the license were issued for regulations of agricultural land and horse side in respect of the pre-1978 encroachment. Page number 26.
You are required to establish these things. You establish it. That you are still in possession, you are willing to vacate, you did not dispossess. You did, why?
Suppose I have made the repetition, right? Still is pending.
No, then see, we are here to enforce a right. That the right means casting an obligation on the authority. Where is the obligation? We don't find, at least I don't find from this regulation. Just because you want something, the court should direct them to give you. Why?
It's a land record, Your Honor.
Maybe
Land records in sketch map.
section, you are relying upon regulation 94. You have a right. You must have applied with the requisite fee. We don't find that you have given any fee. You don't even know what is the requisite fee for this application.
No, in the similar nature of case,
Maybe, it may be, that may be. That does not consider the provisions contained in the regulation. I'm considering the provisions contained in the.
Scope of my repetition. So they can accept or reject, Your Honor. Other case, Your Honor. And it may be considered, my repetition should be considered, Your Honor.
This disposal of representation business is not a very desirable state of affairs. For everything, you cannot have the court's order and go to the authority. Unless if there is a right, of course, we are here to pass the order, but
My
not for
request is on
everything.
the basis of the license, Your Honor, which has been issued by the
You
respondent.
make an application in terms of regulation 94. You are relying upon 94. It says it has to be with payment of such fee as may be prescribed. Where
But
is
the
that?
provisions are contained.
And you have not applied for certified copy. Your application is not for certified copy. You don't want a certified copy.
Your Honor, they have made the file, Your Honor. With respect to my application, they have made the file, Your Honor.
You may be knowing everything.
It is there in the report, Your Honor.
You may be knowing everything, but
Kindly come to this page, Your Honor, the page number 30, Your Honor.
yes.
What is the subject matter is that, Your Honor? The application to collect the premium, Your Honor. So my name also is appeared in the.
But you are sleeping for 9 years. And then you say immediately direct them to do it. You are sleeping for 9 years.
They are taking their own time, Your Honor.
No, you have no concern with anything. We are not going to revive any kind of issue which has already been attained finality. By passing such innocuous order, we only lay the foundation of another proceeding, which I am not inclined to do. You make out a right, we are here to direct, but there appears to be no right. There's someone who is sleeping over his right. Just now you have shown this press note of 2011.
Yes, sir.
It gave you an option that those who have failed, they may do this, they may show these things. You did nothing. In 15, you say they started making some record, you still do nothing. Now all of a sudden after 15 years, you will come and say that they are doing
We
nothing.
do the assessment of the premium. I am ready to pay, Your Honor.
You have not taken any steps. What have you taken steps pursuant to 16 February 2011 press note? Nothing.
I have given the opportunity to pay the premium, Your Honor.
Yes.
Let the respondent should speak, Your Honor.
No, but you have to, in terms of this press note,
Yes.
have to, you see, the licensee proposes to deposit the premium, you have to satisfy the following conditions. So satisfy these conditions.
So if the point number 4 is an application on plain paper along with the original attested documents with an affidavit deposited with the magistrate should be. So I have to made the application, Your Honor. We have shown our interest to pay the premium, Your Honor.
You have not. This was issued in 2000. This was done in 2011. You are coming in 2023, 24. You have not done anything. By now, we don't.
Your Honor, it's representation dated 20. I just submitted at 21st March 2023. Your Honor.
Yes, so this is more than a decade after, 12 years after that.
All the records are proposed by the you have responded.
You could have done this 12 years back. You have not done it 12 years back.
I should given the opportunity to pay the premium.
I don't know why they should be directed to hand over these things to you now at this belated stage.
Let them, they will verify and.
You are relying upon a writ petition which was of 2009. They have acted diligently. You are coming in 2023. Very unique. Why after so much delay? You file opposition. I'm not going to direct. Let an affidavit in
Yes, my
opposition
lord.
be filed. Matter to come in the next circuit.
Number 20, WPS 696 of 2024.
I am appearing for respond number 1, 2, and 3 only.
My lord, I am appealing for respond number 6, my lord, and regarding respond number 4 and 5, they are residing at Tiltra Island. By Friday, they will give me their Basara.
Let us see.
Here, the writ petitioner's father, he was the recorded tenant. After his death, he had only 2 children, one son and one daughter. So after his death, the daughter, he made a representation before the Tehsildar for mutation of the landed property, my lord. Thereafter, my lord, it was mutated, though it is in the joint name. Though it is in the joint name, it was mutated in the 1997, my lord. It is in the joint name, but the relation was very cordial between the between the brother and sister. It was going on. One fine day, that is in the year 2021, when the children grown up, they wanted to subdivide the property, my lord. So they have applied for the records of rights computerized. The petitioner found that it is in the joint name, but in the remarks column, it is at page 22, my lord, annexure P1, my lord.
Yes.
In the remarks column, though it is in the, kindly be seen, it is earlier it was in the name of Atindra Sarkar, that is the father. After the death of the father, it is in the name of Buddhimanta Sarkar and Rebarani Sarkar, two children even, my lord. Now in the column, it is mentioned mutation allowed jointly in favor of Buddhamita Sarkar and Rebarani Sarkar wide so and so. 1,000 square meter out of survey number 137 will be the share of Srimati Rebarani Sarkar, and remaining will be the share of Buddhimata Sarkar. Now this
As per the mutation order.
mutation order.
This is as per the mutation order.
Mutation.
Where is the mutation order?
Yeah, no, mutation, my lord, mutation order is not there, my lord.
Why? You have got it mutated. Where is that order?
My lord, I have applied for it. Thereafter, my lord, this tsunami came in the year 2004.
Yes.
Then I have applied for the certified copy. I have applied for the certified copy. I have got only the some copies, my lord. That is have annexed along at page 25. Kindly be seen, my lord. I have given with this, my lord. Form H. I have applied for entire RC case, which has been on the basis of which the mutation has been taken place, my lord. But they have given with this, my lord. In this, it is mentioned that applied for mutation of land left behind by her deceased father and mother. She intend to mutate the land in her brother's name only. It is there, my lord.
Page 25.
Page 25, my lord. First, second, third column, my lord.
Yes.
It is written, my lord, mutation of land left behind by her deceased father and mother. She intend to mutate the land in her brother's name only.
Yes.
It is there, my lord. The total land, it is mentioned, but during mutation, what they have done, they are saying, I have mentioned that the entire land should be go to the brother only. But I have given with the 1,000. My lord, I never relinquish my share. I never conveyed any deed.
But this is the order of 97, madam.
When I came to know in the year 2021, my lord. Because when I went for the subdivision, my children grown up, went for the subdivision, that time only we came to know that this thing happened. Because in the record, kindly be seen, my lord, it is joint name. It is in the joint name.
Which record? It is still in joint name.
It is in the joint name, my lord.
Yes.
It is at page 22, my lord. It is in the name of both the.
It is, but share has been defined.
Share has been defined. I never relinquished, my lord.
We don't know how can it be said now so late in the day.
Now, my lord, kindly be seen the first. It is mentioned. I have given entire land to my brother. Why?
All right, it may be incoherent. It may not be making sense, but it has attained finality over decades from 97 till 2024, 25.
Now the report has been called for. In the report,
Nearly 30 years, more than 30 years.
Filed some document. It starts from page 33, my lord. During the hearing before the deputy commissioner, because I have made a representation before the deputy commissioner by saying that correction of the record in the year 2021, my lord. When I came to know that the land has only been, it is mutated, but some share has been given.
What is at page 33?
My lord, it is an affidavit. In this affidavit also, there is no stamp paper. It is just mentioned, it is an affidavit by saying that entire land should go to my brother.
Yes.
My lord, this is
signed by you.
My lord, next kindly be seen, my lord. Next, 34. This is the notice.
This is also signed.
Notice.
Page 33.
Form J also, it is contains that the entire land should go to brother. My lord, this is the illegality done by the Tehsildar, my lord. Why I say so, my lord? Because it is in the joint name. It is in the joint. If I say the entire land should go to my brother's name, there should be some deed, my lord. Without a deed, by saying it cannot be, my lord, because they are Hindus, my lord. They are Hindus.
Nobody is prevented from relinquishing one's right.
My lord.
For that, no law is preventing you from relinquishing.
There should be a deed, my lord.
There is an application affidavit signed by you upon that they have relied.
Saying on anything. Why the Tehsildar has given that thousands.
Where is the affidavit is at page 33?
It's at page 33. If I believe this, my lord, in that situation, what in the third para it is mentioned, I have no objection to mutating the land in my brother's name. Then why the Tehsildar has given thousands square
So
meters?
what do you want now?
It should be in the joint name, my lord, the remouse column. That has illegality has been done, my
So
lord.
this
There.
mutation which has been done, there is no remedy against this mutation order.
My lord, we have filed an application before the deputy commissioner for correction. He has rejected it on the ground that
Where is that rejection?
it's at page, my lord, page 30, my lord. By mere saying that, page 30, my lord. 32 is the relevant page, my lord. 32 is the relevant page.
Yes, you are appearing.
Yeah, I am appearing for respond number one.
How can you support
and
this
three.
order? He says that she has relinquished her share and then he says that allotment of 1000 meter is correct. How can both be sustained? Either she has relinquished or she has sought 1000 meter. It cannot be both.
But she herself has filed the application for mutation in the year 1997. And after that, she has never raised any objection.
She has filed saying what?
But if I am relinquishing.
She is filed saying what? Come to page 33. You are relying upon this. If this is the affidavit you are relying upon, then why did you give her 1000?
This is regarding only one survey number. Can you see in the paragraph 2, my lord?
137.
Only regarding one survey number. The one survey number, entire share has been mutated.
Where is the other survey number?
Yes. The other survey number 1600 for 1000 has been given to.
This order of the DC is in relation to 137 only.
No, my lord, there are two survey numbers.
Please come to the order of the DC.
Yes. Survey number 137 and survey number 222. Page number 1 of the order, my lord.
So from the DC's order, please show that the order is only in respect of 222.
Order is in respect of two survey number, but the affidavit which he has relinquished regarding one share, that is survey number 137, area is 2.02 hectare. That entire land has been mutated in favor of the brother. In that survey-
137 entire has been mutated in
in the name of the brother.
So show from the order that 137 had been entirely mentioned,
Yes.
mutated in favor of the brother.
Yes,
And this 1000 is only for 222.
yes. I will see. Yes, paragraph order gist of the case. First page of the order, page number 30.
Yes.
The land in question, survey number 37, area is 2.02 hectare, and survey number 222, area is 0.14 hectare, was originally recorded in favor of Sri Atindra Sarkar census. Upon his death in 1994. His two children were legalized. The petitioner applied for mutation. The mutation was carried out in 1997, but the petitioner was not aware that such, which was recorded as 1000 square meter out of survey number 137.
So what is the basis? That is what I'm trying to understand. The court wants to see the basis for such conclusion. You say that 1000 square meter was recorded out of 137.
Not 137, that is 137, the entire share is recorded in favor of the brother. Yes.
Just now you have read.
Yes, there is a mistake. Kindly see the page number 38.
38.
Or equal to 38.
38 also 1000 out of 137. So if she has relinquished her share in 137, how you are giving 1000 square meter?
That is.
And paragraph 3 of the affidavit is saying that entirely may be recorded in the name of the brother. Then why you have given a 1000 square?
I shall take instruction and come back.
What instruction? This order is unsustainable. What
My another point is that this is an appealable order also. There is a
before
the Secretary Revenue as per
No, no, no. This
regulation
is an illegality done by the.
regulation 28.
Where is the order? Where is the provision?
Regulation 28, my lord.
Then you go before.
For this.
28 regulation.
Action of this honorable court to dispose of the.
If there is an authority, you go before the authority.
Not for illegality, my lord.
Regulation 28.
Obviously, if it is a legal order, why will you go? You will go only if the order is illegal.
If there
is a legal order, nobody will go to the appellate authority.
So the petitioner has preferred the.
Regulation
Preferred a
24,
petition
28.
for this court, my lord.
Yeah.
Subclause D of regulation 28, my lord. If such order is passed by Deputy Commissioner,
Subdivisional officer.
Here the order is passed by Deputy Commissioner.
Whether or not invested with the power of the Deputy Commissioner. D perhaps.
Yes.
You have to go before the chief, instead of chief commissioner, now it is the secretary.
Secretary Revenue.
Secretary Revenue is the respondent.
No, my lord.
You impede him, then we can direct, if you approach him, he will dispose of. If you impede him,
Before passing this order, my lord, I have preferred a writ petition, my lord. That order is also annexed, my lord.
all right,
Lord,
nobody is
this order has
disputing
been
that.
passed.
All right, so then what is that? What does that mean? Now you cannot be sent to the secretary. Then you go before the secretary. If there is a provision, why should the High Court unnecessarily go into this issue? The writ petitioner
There
alleges
should be a time frame
you are not included in how he can be, direction can be issued to him.
because the order has been passed by the deputy commissioner, so I made him as a party as well as the Tehsildar who has passed the original order.
If you want the direction to be given to the secretary, he needs to be a party, otherwise how can a direction be issued to him? That is what I am saying from the last.
Maybe given liberty, my lord, I will.
Yes, the learned counsel for the petitioner submits that she would be taking steps for impleading the secretary. What is the designation? Revenue. Within bracket revenue as a party respondent. Let appropriate steps be taken. List on, give the date of day after tomorrow.
Oblige.
I do oblige, Your Honor.
Day after tomorrow. Yes.
Number 21.
Service is not affected. Let it come in the next week.
As per list after.
Next.
Sunday. Wednesday, give the date of Wednesday, next Wednesday.
Item number 22. Year of 33 of 2024.
Tulsilal is up, he is on leg in other court, where do you pass on?
Not today.
Item number 23. Year of 56 of 2024.
Lordship, I am for the petitioner. Lordship, there are three identical matters, Lordship. Two are placed before this honorable court and one is at court number 2. I have made a submission there to that item to be released.
So let us take up whatever is here. We'll take it up. That will come, that will follow. Respondent. Two.
Service upon the state has been completed, Lordship.
I am appearing for respondent number 2.
I am appearing on behalf of my senior Mr. Sunit Karnakar on behalf of the state. The state is the performer.
You are the contesting respondent.
My lord, I am raising a maintainability issue, my lord.
Lordship, can I pray one thing, Lordship? This matter will be fixed on Monday, all the three matters.
Why you let us proceed with whatever is here? What is the fun in having all three together?
Lordship, all three are identical matters.
There may be hundreds of cases like this. All of them have to be heard together.
No, Lordship, actually,
We pick up one case at a time. What is your grievance? Which order you have challenged?
Sir,
Page 44 is the impugned order. My lord, it's not maintainable, my lord. Revision is not maintainable. Appeal will lie.
Lordship, page number 45, last paragraph is the impugned order, Lordship. Lordship, three identical mixed execution case were filed by the petitioner wife before the Honorable Family Court. After the service, the husband came before the Honorable Family Court and they filed their written objection.
It's under 125.
It's under 128. That's the main catch, Lordship. I am grateful that the Honorable Family Judge by a judgment of 1988 from Bombay High Court rejected the three mis-execution cases on the status that it is under 125(3). Lordship, kindly come to page number 18, Lordship. 18, Lordship. Kindly page number 18. That is, in that, it is the petition under section 128. And the judgment and the impugn order is being passed under section 125(3), Lordship. My instant mis-execution are within the time limit as under the statute. In this, Lordship, a order of lok adal was there of rupees 5,000 to be paid to the wife in the 2010. The husband is a clerk, Lordship, earning more than rupees a lakh. He is not able to give rupees 5,000 to his wife, Lordship. And as such, the petitioner wife has to find 5 mis-execution cases. 3 of the mis-execution cases are before this Lordship. Mis-executions of rupees 60,000 instant cases before your Lordship.
It has been rejected as being time barred.
Yes, Lordship. The judgment says, Lordship, it should not be
preliminary.
Lordship, that's a very small issue.
You already said that, yes.
Lordship, the judgment says that the period for which the maintenance is asked should not be more than 1 year. Lordship, I have filed the instant mis-execution case 364 days. It's within 1 year, Lordship. And with that judgment of 1988 Bombay High Court, the instant mis-execution case has been disposed by the Honorable Family Court. Lordship, kindly appreciate that Honorable Family Court is a
Where is your application which was considered by the court? Where is a copy of the application?
Page 18.
Page 18, Lordship. And Lordship, the heading says petition under section 128.
How many times?
Sorry.
Enough. I have understood. Not under 125, order passed under 125, application made under 120.
Grateful, Lordship.
You said a sufficient number of times.
Grateful.
Where is the order of the Lok Adalat which you seek to be enforced?
Lordship, page number 27. An order of 2010, Lordship.
Yes, what is your objection?
My objection is that, my lord, under the Family Courts Act 1984, against the interlocutory order, revision will lie. This is final order. So appeal will lie before the honorable division bench. Yes.
Which provision?
19, my lord. 19(6).
Yes. Go through the provision. You go through the provision, the correctness of the order is, it will come after this objection. You have to meet this objection. Either you have to convert it or you have to tell me why this objection is not maintainable.
Lordship, in that case, that matter be, Lordship. Tomorrow, Lordship, I will come with.
Not today.
I'm grateful, Lordship. Grateful.
कृपया करके डिवीजन बेंच में डालें।
This is serial number. This is serial number. 23.
and 24.
Both. By the same person.
Yes, yes.
All right.
Item number 25. CO 44 of 2024.
Actually, in this matter, my senior appeals for the petitioner. The service has not been completed. Let it be in the next week.
As paid Wednesday.
Lord,
Okay.
I've been appearing for 1, 4, 5, and 7. Lord, in the respondents.
Give your appearance.
1, 4, 5, and 7. Blair.
Wednesday, sir. Okay.
Item number 26. CO 54 of 2024.
For the petitioner. Lord,
Yes.
the trial court, during the pendency of a suit seeking protection against illegal eviction by the plaintiff, by order impugned, passed mandatory injunction, thereby directing defendant to allow the plaintiff to put into possession of the suit property. The order was at the first instance assailed directly before this court. Some interim protection was granted, but a point of maintainability was raised that since such order acquired its color under Order 39, Rule 1 and 2, then the first appellate court needs to be approached. Then it was withdrawn. District judge was approached. Appeal was preferred. The district judge dismissed the appeal, against which this revisional application has been taken out. Just show the order of mandatory injunction. I have not paginated since a certified copy. I have not even, not would see it's an order number.
Just give me a minute.
Mal.
Yes.
But my point is, the suit was one suit seeking illegal eviction and.
You are appearing for the respondent.
Yeah, from a respondent.
And it's a suit for degree of permanent injunction, which is based, it's a plaintiff case, Lord. Plaintiff has asserted, Lordship, that she is in possession of these suit premises. Lord, on 28th October 2024, suit was filed.
Yes.
Mandatory injunction was sought for to putting the plaintiff back into possession. The very suit, because the entire suit runs with this pleading that the plaintiff is in possession. The trial court granted mandatory injunction asking my client to put plaintiff into possession. Fact remains, even before filing of the suit, on 25/10/2024, the plaintiff voluntarily surrendered the tenancy because there was a tenancy agreement existing initially. It lasted May 2024. There was no extension. She voluntarily surrendered the tenant premises. I took the possession. But she filed the suit on 28/10. But by allowing a mandatory injunction, the entire issue involved in this suit has been decided at the very initial stage. It's the matter of trial to be gone into. Because I can understand Order 39, Rule 1(2), temporary injunction, prohibitory injunction, I can understand. Restraining one party, maintaining a status quo, but putting back one party into possession by way of a mandatory, it's unknown to law, right? It can be granted. There has to be an extraordinary case. There are judgments I've brought, Supreme Court judgment. It's not the requirement of Order 39, Rule 1 and 2 is one thing. But order under 37 of Specific Relief Act is something else. There has to be an extraordinary case. Then only a court can exercise the power to grant a mandatory injunction. In the present case, the trial court in a very casual manner, my lord, granted the order. Now kindly see the tenor of the order once. Lord, kindly takes the impugned order of the court below, my lord. The court of first instance.
Yes, I've just gone through the.
My lord.
Yes,
Yes,
court
my lord.
proceeds that it cannot be a presumption.
I could have understood when the suit was filed, there was a status quo order operating. I have disturbed the possession, I can put back the plaintiff into possession. The suit was filed after the tenancy was surrendered. Tenancy was surrendered on 25/10.
Where is the plaint?
I'll just surrender, sir.
Where is the copy of the?
I'll just. Not would find the plaint.
It was not surrendered, my lord.
At page
My lord, it
14,
was not
page
surrendered.
14 of my application. They of their own share of their own set, that 25/10 have been removed. Even if she is removed, Lordship, the remedy is well recognized under section 6 of specifically back.
Page 14.
14, yes.
14.
Of the revision application. 1/4.
Part of the.
Immediately after the affidavit of this.
After the affidavit.
Immediately after the affidavit. I would find the copy of the claim.
P1.
P1, letter P1. May I read for the court now?
No, I'll just.
My lord.
You admit that you had been thrown out.
Yes, Lord. At best, the suit could have been sued for restoration of possession. This can't be the suit, Lord. But by granting that impugned order, Lordship, the possession was not to put something unknown.
Paragraph 29 of your plaint.
My lord, we are suffering this matter due to non-interference of suit. We are getting huge loss in market in terms of money and
Please
reputation.
read
It cannot
paragraph,
be
please
compensated.
read paragraph 29 of your plaint. Your client says already thrown out. Where is the question of protection against eviction? Somebody is appearing online. Who is he?
They are, he's with them. He's with them.
Who is the lead counsel? He is the lead counsel.
Yes.
Paragraph number, sir. Read paragraph 29.
You will not make any threat, inducement, or promise of any person acquainted with the fact of the case. So
Sir,
as to
we are asking you to see paragraph 29 of your plaint.
Okay, sir.
Paragraph 24, 25, 29. Your admitted case is that you have already been dispossessed.
And an FIR has been lodged for against me for trespass, Lord.
No, my
And
lord.
I'm taking the position.
Don't say no without looking at your client's case. First, see what your client has
Sir,
said.
here kindly see page number 10 here, paragraph number 1.
Who is arguing? You are arguing, or he is arguing, or the gentleman who is online is arguing? Who
The
is arguing?
gentleman who is on the line will argue, sir.
All right. Please,
Yes, second.
please allow him to submit. Yes, Mr. Kumar.
Sir, it is there. I also find prima facie that on 23rd, when a legal notice was served
Not coming.
to the
This is the
landlord.
way anybody will start making submission. I asked you who's submitting, you said that he is to.
Yeah, he
argue.
is.
Can't hear him. How can such a relief be granted? The main prayer in your suit appears to be the facts. Prima facie, it appears to be unavailable. This relief is not available. And you have not claimed any restoration of possession. If that's not a main prayer, how it can be passed as an interim relief?
Your Lord, my submission is that the two of the subordinate court, the learned Chief Judicial Magistrate and the learned Court of Sessions, they have given the already heard and given the judgment in favor of me. So likewise, my submission is that the judgment may or order may please be given in support of the two of the lower courts, judgment of two of the lower courts.
You have come with some judgments.
Lord, I will just write just one celebrated judgment aptly on the point. Lord, when this power of mandatory injunction can be exercised by court, I'll just show that. Just one second.
And my client is suffering very badly because the materials of the shop as well as of the tailoring shop, both are lying outside and it is in the rain, under the rain, and it is being worn out. the new commodities, or and they are
Just 1 second.
feeling and having an irreparable, we can say so.
So this Kosa judgment, Your Lordship, this has been cited by the court. Yes, ma'am. This
For
judgment-
Dorab Kosji,
Yes, my lord.
you're relying on Dorab Kosji.
Yes, yes. Where, Lord, the standard of satisfaction
Yes.
while granting mandatory injunction requires more, Your Lordship, as compared to temporary injunction. And this has been discussed in this judgment also. And my lord, trial could have discussed also that judgment was cited, it was not taken care of in proper perspective. It's not easy to grant a mandatory injunction, Your Lordship. Particularly in the present case, it can't be done.
Before that, a relief which is not when a final relief is not
Absolutely not.
claimed, an
Absolutely
interim
not.
relief can only be granted in aid of the final relief.
The frame of the suit is bad, my lord.
Frame of the
It could have been but restoration of possession because they are out of possession. Absent of finding of the court below, which was affirmed by the first appellate court.
Yes.
Our submission is that.
Why his voice is not coming? Yes, Mr. Saket Kumar. Cannot hear you.
Due to network problem.
Now you are audible. Yes, now I can hear you. Yes. There is. What is it? You are relying on any judgment? How do you sustain the order? He's local.
No, he's from Delhi, my lord.
Can't hear him.
Well,
Better audio visual system. When the matter is taken up next on, give the date of Friday.
Like.
Right. That's fine.
CO 58 of content report.
Lordship, I'm from the respondent. Mr. Shamanto, my learned senior, is appearing on VC.
Yes.
Listed. So Mr. Samanta told me that he will pray for release this matter in that court. Yes.
My lord, actually, 3 other matters were heard by the other bench.
Already.
So I thought it will not reach. That is why I said but since it has reached, my lord, your lordship can take it up. I don't have any problem on that.
Taken up the matter.
Yes, Lordship, today.
Yes, lordship will take it up.
Very well. If the other court has already proceeded, then let it go. What is the number of the case before?
Milord, those are disposed of, Milord, 3 matters, 5, 6 and 7.
Connected.
No, not connected, Milord. They are different, this thing. Actually, 4 matters were filed, 3 went to the other bench and 1 came to your lordship's bench. There is no problem, your lordship will take up the matter. Milord, it will take hardly 5 minutes, let my learned friend submit. Subject to my lord's pleasure. Not connected.
And not connected, then why should we should proceed? Yes.
Lordship does it, Milord. I'm there, Milord.
The case, partition suit was filed in 2021. Defendant engaged one counsel who appeared and filed a petition with undertaking to file wakalatnama. Years lapsed, 1.5 years. Then another counsel appeared, filed wakalatnama, no written statement, no written objection. Addendum injunction was granted. Then receiver was also appointed. Then receiver, as soon as appointed, the third counsel is coming by filing different petitions, which was also allowed, one of the petition. My only
What petition was allowed?
For ex parte vacating order. My contention
So
is
after that, did they file a WS?
they filed WS that has not been accepted. Other applications they also filed.
Those are pending, Milord, and the next date is 17/1.
My contention is only because.
Just a minute, when the ex parte order was recalled.
Yes.
They must have been allowed an opportunity to file WS.
Yes, Milord.
Please, Mr. Samantha, please wait. Yes.
I'm sorry.
So when they were allowed time to file WS.
No, they already filed. Page order number 23 may be seen.
Order number?
23.
WS accepted, subject to payment of cost, we have paid the cost.
So which order is you have challenged?
Oh, Lord,
This order.
Here for expedient disposal of my title suit. Because
counsel
other
for
court
the
also granted 6 months time.
counsel for no question of time fixed. You must have seen the Supreme Court judgment.
Lord,
Don't make
they are
submission.
enjoying entire property.
Whatever it is,
more than
learned counsel for the appellant as well as the learned counsel for the respondent appearing virtually. This is a revision, revisionist and the learned counsel for the opposite party appearing virtually. The revisionist is the plaintiff before the trial court in a partition suit to stop the respondent's application for recall of order whereby the suit was directed to proceed ex parte and having a composite prayer for allowing filing of WS has been accepted by the trial court. To stop, the WS has also been accepted subject to a cost of rupees 2,500 to be paid to the plaintiff. To stop, it's not in dispute that this order has been complied. To stop, learned counsel for the revisionist, however, raises a grievance that after resorting to many dilatory tactics, including change of counsels, the this defendant in the suit has unnecessarily protracted the litigation at the stage of filing of WS itself. Stop. The learned counsel, Mr. Samantha, submits that now the WS has been filed and therefore it is only obvious that the parties have to proceed with the suit in accordance with law. So, considering the rival submissions and since the primary grievance of the revisionist seems to be expeditious disposal of the suit, we only observe that the trial court may proceed with the matter expeditiously without granting any undue adjournments or unnecessary delay.
Lordship, I'm grateful, Milord. I'm grateful.
And stands disposed of.
Item number 28. There are 59 of 2024.
Lordship, Lordship, Ms. Senior appears for the petitioner in this matter. Can it be in the next week?
As prayed next week.
All right.
Number 39, WPA 428 of 2024.
I am appearing for the respondent.
Yes,
Affidavit of reply today file, we have to file today only. Just let me fix on Monday or Tuesday.
you are filing it today.
Already filed.
Affidavit in reply has been filed today. As per submission of the learned counsel for the respondent full stop. He seeks the matter to be, he makes a prayer that the matter be taken up on Monday. Stop list accordingly.
Lordship, as prayer of the petitioner.
Yes.
Your Lordship has respond.
Oh, prayer, this petitioner. Monday.
Number 30, WPA 497.
Lordship, I am appearing for the respondent authorities. Lordship, there is a direction upon me to file opposition. Let it be fixed on Tuesday next, Lordship. I will, in the meantime, I will file my opposition.
None appears on behalf of the writ petitioner. Let the matter be listed on, give the date of Tuesday for stop. Learned counsel for the respondent submits that in the meantime, he shall be filing the affidavit in opposition.
Item number 31.
Same,
WPA
Lordship.
124.
Same order.
Item number 32. WPA 502 of 2024.
Same, Lordship.
Item number 33. WPA 525 of 2024.
Here also there is a direction upon me to file opposition, Lordship. I have prepared it. I have sent it to the department. Waiting. It is under waiting, Lordship. Let it be on Tuesday. I will file it.
This is not a matter akin to other matters. Those are fresh connection. Here unilaterally authority have snapped my connection. Changed
Connection for?
Electricity connection I was enjoying, my lord.
Alright.
It was given in the name of a third party. Without hearing, I am residing there in the property. I was paying.
I will use, I have already prepared it. I have sent it to the department. On Tuesday, I will file my opposition. Lordship.
Let him file it.
Come, let him exercise privilege.
The affidavit in opposition is to be filed by, give the date of Tuesday, comma, as per submission of the learned counsel for the respondent. List on, give the date of Friday. In the meantime, if required, the petitioner's counsel may file a reply.
Item number 34.
All these are electricity matters.
Lordship.
What is the
Up
problem?
till 39.
34. WPA 607 of 2024.
Yes, what is the position in this same
Same, Lordship.
as 33?
No, Lordship, at 32.
Same order.
Thirty-five. WPA 685 of 2024.
Here no direction is there, Lordship.
Yes, let us see. Why are you not granting the connections?
They are the encroachers, Lordship. Encroacher of the government revenue land.
There is a supply code.
Regulation is there, Lordship.
Where is the regulation?
I have not brought it. I will bring it on the
So
next.
there is no provision for supply of electricity.
No, supply is there, Lordship, but there is certain formalities they have to fulfill. They are not fulfilling that formalities, Lordship. So,
is there an order of rejection?
No, in this case, there is no order of rejection is there. Let direction may be given to the respondent to dispose of the representation of the Writ petitioner, Lordship. Application of the writ petition.
He is not here, not today. Let us see if he comes tomorrow. None appears for the petitioner. Matter stands adjourned for the day.
Lordship, 36 to 39, I have not received any copy, Lordship. No, neither I have received any brief.
Let's see if somebody appears.
Number 36, WPS 706 of 2024.
Why have you not given a copy?
Not complete.
Give him a copy. What service?
I will give, but yes, please, it will to drop the copy to the department.
Lordship, because I have
You
to
are not
take-
authorized to receive.
Lordship, because I have to take instruction after serving them, Lordship. Because
Lordship, this matter may fix on Monday. In the meantime, I will serve and file.
What is your prayer? Let us see.
same.
Last day also you are submitting that you will serve. Why you don't want your matter to be considered? On December 13 also you have said that service is not complete.
Reason is that, my lord, receipt copy is missing. That's why I have to again serve the copy to the department.
But it's been about a month, sir. It's not just yesterday.
Page 17 is the application.
No, but where is the settled possession? Page 17. This is what we are asking you. I was asking you, is there any supply code?
Yes, Lordship. JRC regulation is there, Lordship.
JERC regulation 11 of 2010.
No, it has been amended 2018.
2018, what, where is it?
I will bring tomorrow, Lordship.
Bring it tomorrow, it will come tomorrow.
Let him give a copy to me, Lordship. So
Give him a copy. Not today. A copy of the writ petition is being handed over to the learned counsel representing the respondent. Respond number?
All the respondents.
All the respondents. Stop. Lists. A matter stands adjourned for the day. Just come with the recent regulation governing grant of connection. Now in many states, we see that even for those persons who are not able to produce a right to the land, at least for the sake of not losing electricity revenue, the board has
very
provisions.
recently, Supreme Court has held one judgment, Lordship. I will bring that judgment also.
Yes.
Without proper building plan, if anybody has constructed the house.
No, that is a different thing. That's not your issue. You are saying land possession is not certified.
Yes.
That is not the issue. Without building plan, of course, it cannot be granted. It will become hazardous. That is a different concept altogether. Yes, we'll see. Come with it tomorrow. Yes.
Lordship.
WPS 708 of 2024.
None appears. The matter stands adjourned.
My lord, I am appearing for the
In
item number 37.
Yes.
Service not affected. I will copy to
Let them serve the department, Lordship. Let them serve.
How
the
much
department.
time do you need for serving a copy? Last day also you are taking time. What is this? You are not interested?
day accommodation. That's also.
As pleaded by land counsel for the petitioner to comply with the earlier order regarding service. Matter is adjourned. Give the date of Monday.
PT face would show that we are exhausted. All the lawyers. It's four, it's going to four.
4, time is till 4:30, no?
It's there, Lord Shiva. Because we, the set of lawyers, do the practice in the lower courts also. 8:30 early morning he comes.
Applied here, and it was kept here. Then at some point of time, an inspection was carried out by the Central Drug Control Laboratory, and they have taken one particular medicine manufactured by us a year and a half earlier, and they say that it satisfies all the tests of purity, the necessary ingredients, everything. But one test it doesn't satisfy is a test of the time it takes to dissolve in water. Based on that, they have started a proceeding against the Drugs and Cosmetics Act by filing a complaint against a company, 3 partners who run the company, and 3 staff of the company who are the chemists and pharmacists who are responsible for the actual manufacture of the medicines. On the basis of this, a summons was issued in the name of all.
Now, we have come up in quashing on two grounds. The first and the most interesting ground is this. Under the Drugs and Cosmetics Act, there is a 482. It's in that book in mind. The books are there, the files.
My lord, should I
Now-
say two lines? Yeah. We are appointed to the Ministry of Law. Either the concerned ministry approaches the Ministry of Law and Ministry of Law appoints us. And otherwise or the ministry directly appoints us with the intimation to the law ministry. Here, after lot of despite service none appeared, I was appointed by my lordship. And I was appointed by my lordship on 10th of February, 10th of December 2024.
The court had asked me who usually appears for the Union of India, so
And-
I had indicated
and
Mr.
thereafter-
482, quashing.
Question.
But in Calcutta, this is because in the Calcutta High Court, 482 is filed under criminal revisional jurisdiction. It's part of. So, in fact, usually a lordship will find 397, 401 is not invoked for quashing applications. The CRR will be under 482. Now, of course, 583.
But there,
It is filed in the criminal revisional jurisdiction.
I am representing my lord, but I have not received any instruction so far. Immediately thereafter, I sent a letter to the concerned department on 11th of December. Then thereafter, 12th of December, taking in the loop of the legal law department also. And I requested them, and there is a letter thereafter. I requested them to come over and let me discuss the matter, what the matter is about. Unless and until there is a discussion across the table, I will not be able to understand what the matter is all about. On the last letter was sent on 6th of.
In our usual practice, it is served in Calcutta. What we do is we serve it directly on the office, which is at Nizam Palace. This matter was originally filed at Calcutta. It was served there. No one responded, no one did anything. Then the matter was transferred here with the circuit. In the meantime, there were some difficulties with the council. I was asked to take over. And I served afresh. Again, we filed the affidavit of service, everything. Now, the problem that I understand is the office is based in Calcutta. They do not have any officers or officials here. Now, they have to communicate with Mr. Lal. Because this bench was finding that repeated services, no one's bothering to even take time or anything. I was asked who appears normally. I said Mr. Lal. So the court has asked me to serve him. I've served. Now he is connected. He should be able to get the instruction. And I'll tell you, Lordship, why. This is not the usual course of matter. This is really, whichever way it goes, it's a beautiful point of law. The Drugs and Cosmetics Act has a very unique framework for fixing liability of corporate entities and their officers. Your Lordship knows in usual criminal jurisprudence, anyone who is responsible for the affairs, day-to-day management of that company or a juristic entity would be criminally liable in terms of the interpretation that is there. Under the Drugs and Cosmetics Act, any firm which manufactures medicines, when it applies for the license, it has to satisfy various things. But the two most important things are, A, it must give the formula for every medicine, which is step by step. I mean, if it says take a silver spoon, 1 spoon of this, put 1 spoon, you have to do it that way. The second thing is, you have to appoint designated persons, an analytical chemist, a pharmacist, and a person who has certain advanced degrees in this field. Those persons will be intimated to the government. The government will issue the license in the name of the company, but referencing these people. They have to sign off on each and every step. Now, this matter is similar to a set of matters which have been considered by the Honorable Apex Court and other high courts in the country. Under the Drugs and Cosmetics Act, it is those persons, who are responsible for anything to do with the manufacture of that batch number of the medicine. So, it does not follow automatically that the company and all its directors, partners, everyone will automatically be dragged in. So, the question here is under the Drugs and Cosmetics Act specifically, there's a different regime to affix corporate liability. This matter is about that. That is why my learned friend requires the instruction. Even more importantly, I can just indicate from the petition 2 or 3 pages, which will make the entire situation very clear. If your Lordship permits me, I can do that. My Lord. My lord, then. But the only problem is we are at an impasse because over the last 6 months this is going on. Now finally, this honorable court has granted me a stay.
I am
He is-
making,
he
I
is.
am making all of my efforts, but last letter was sent on 6th of January. Right, it started from 11th December onwards. My engagement was on 10th of December. I am taken in the loop,
Which respondent?
you pardon?
The respondent number one. Opposite party number one, Union of India through the Drugs Inspector, Central Drug Standard Control Organization. Page 3 of my petition, my lord.
I have contacted the officers of the Nizam Palace, the Department. Law Ministry. I informed the Law Ministry that despite, you might not, right, on 11th December itself, my lord, the first letter, first email. Then, my lord, then 12th December. My lord, 10th December, my lord, 11th. I sent a letter on 11th December, taking to do the law department as well as the CDESCO.
That's
It is up to the.
My only urgency so far as this proceeding was concerned is that the interim order exists only till the end of this circuit. Because
16th of December.
The order was passed.
16th of December.
Has not received any. Require at least how much time? 2 weeks time. Time for taking instructions. Only appropriate that in every model. We extended in the past day on the next side. Very grateful. It's